Submission item number 1.
My lord, kindly taken up next week for filing a counter affidavit. What's the matter about? I don't know. Was notice issued? No matter.
No, no. Item number 1 is very bad. Notice of not.
Remove encroachments.
Yes.
Who has put up encroachments? You say the petitioner's representation. The proof of bracket annexure 2 series will be examined by the Tahsildar Nimapada, and after notice to petitioners and opposite parties 4 to 7 and giving them a hearing, the reasoned order should be passed not later than 10th April 2023. A copy of the decision we made available to the parties within a week thereafter. The court clarifies it is not supposed to be in the matter.
Supplementary list item number 2. Item number 2.
My lord, it relates to I am for the opposite party, my lord.
Let's see who's for the petitioner.
It
1 minute.
relates to-
1 minute, sir. Let us see who's for the petitioner.
Yes.
Pass over.
Item number 3.
Item number 3, my lord, on behalf of Mr. Senapati, can it be passed over, madam?
Pass over.
Item number 4.
May I please, my lord? Petitioner challenge the arbitrary illegal detention of the vehicle and goods on the way by the state enforcement and collection of tax and penalty, even if the invoice and EOA bill accompanied with the vehicle. Petitioner filed appeal against that. Appeal has been confirmed. There is no second appeal tribunal constituted.
How much have you paid?
All tax penalty has been collected by the enforcement.
Release now.
Vehicle has been released.
All right. Since the second appellate tribunal is not in place, the court is constrained to entertain the petition notice. Mr. Mishra accepts notice on behalf of opposite parties. Opposite parties.
1, 2, 3.
I am for the 4, madam.
Right. He's for the 4. Mr. Sarpati for the 4. Replies be filed within 8 weeks, rejoined for the next date. For the IA, you say, counsel for the petition informs the court that the entire tax and penalty has already been paid. They appeal the matter till the next date. No coercive steps during the pendency of the petition. No coercive steps shall be taken against the petitioner. The application is disposed of. The other IA is what? There are 2
Call
IAs.
for records.
Call for the record. All right. It's allowed and the record is called for. List on 17th May.
Item number 5.
Item number similar.
All right. Same order. All right.
Item number 6.
Item 6. In this case, I am challenging the first chapter of the order.
How much have you paid?
Report rejection.
How much have you paid, sir?
Sir, this is refund, sir. Refund rejection order, sir.
Rejection of refund.
Sir, not sir demands.
All right. Notice. See, he accepts notice and reply within 8 weeks, rejoined for the next date.
Your Lordship, I am appearing on behalf of opposite party number 1 and 2.
Lordship, I am appearing for the opposite party number 3.
3. All right.
4 and 5 notice may we go.
Sir, 5 review.
5 Miller
5, Mr. Manti. 4 notice will now go to opposite party number 4. Returnable on the next day. Replies be filed within 8 weeks of the service of notice. Rejoined for the next date. List on 11 July.
Item number 7.
May I please, Your Lordship? My Lord, yes, 7, yes. My Lord, the petitioner is challenging the order of the Commissioner, Your Lordship, which is at page 13, Your Lordship, Annexure 1, in which then the IMFL of SOF has been directed to be shifted from Bodville to Joda, your ward number 8, Your Lordship. If Your Lordship will see
You
the,
go to the commissioner against this order.
yes, Your
This
Lordship,
is Commissioner's order.
Collector's order, you says,
No, my lord, Annexure 1 is
commissioner.
Commissioner.
Excise Commissioner.
Ah,
So Your Lordship will see, my Lord, may kindly see the letter, this order, the above liquor shop is allowed for shifting from existing site to new site subject to fulfillment of the following conditions. My Lord, may kindly see the last condition. The registered rent or lease agreement to be furnished before the collector council before physical shifting. If Your Lordship will see at page 38 of the writ petition, Your Lordship, which is on 30th of November 2022, letter dated to the Superintendent of Excise Keonjhar. With reference to the subject cited above, I beg to report that as per DEO Keonjhar Director number so and so has the shop has been shifted her shop to plot number so and so municipality on 30th of November 2022 from existing site. If Your Lordship will turn the next page, Your Lordship, the lease agreement is on 19th of December. That means when the shop was shifted, on that day there is no lease agreement as per the condition mentioned in your in the Commissioner's order, Your Lordship. Your Lordship, clause 5F of your the Commissioner order that before shifting there should be any registered sale deed, registered rent or lease agreement. But the shifting was
or this is notice, Mr. Mohanty accepts notice for 1 to 4. Notice will now go to opposite party number 5, return of the next date. Replies be filed within 8 weeks, rejoined for the next date. 16th May.
my lord, I am moving filing an IA, Your Lordship, for the stay of person of this. My lord, what is happening here? There is a report of the inquiry officer in which they have stated that if the opposite partner of 5 actually wanted to surrender her license, but the government ordered for shifting of that, and there are 3 offs off and 2 ons
Let
off.
the replies come. Sir.
So actually, MG, the problem is that, Your Lordship, that now the condition for picking up the MGQ is been cannot be maintained because of there is a new shop. MGQ,
You're
because there is a
combining two
condition,
things.
Your Lordship.
MGQ is a separate cause of action.
No,
This
I'm
shifting is a
understand
separate cause
because of the shifting of the new shop, there's a drastically change in the selling of the my.
This is
Anyway, all
very
that
common-
we take after the
common
replies
defense.
comes. Right.
My Lord, then Your Lordship, I kindly fix it so that it will be reported.
We need 8 weeks.
Because there are lots of violation in this, Your Lordship. The public notice has been issued for the ward number 6, but the
First May. All right.
First May.
Item number 8.
Mike, Bhattacharya.
There is an application before the Honorable Court under section 161 CPC for considering the facts as mentioned in the petition. My lord, at the time, my eyesight also not proper, and it has been tested. It is found that some cataract has been developed.
Stand the order. There is a petition.
Cataract has been developed, and they have suggested for
review
surgery and all
petition,
that. For that, I am not able to see properly.
Say anyway, this is not maintainable, sir. After review petition, recall and all is not maintainable. Review petition has been dismissed on merits. We have dismissed the review petition on merits. There is no option to recall, sir. Recall applies only if it is dismissed in default.
Oh, my lord.
Now you have to go for the next level, sir. That you ask any lawyer, they'll give you advice. We are not in a position to give free legal advice. You say this IA is not maintainable and is dismissed as such.
Thank you.
All right.
Item number 9. Item number 9.
None appears dismissed.
Item number 10.
May I please, my lord? There are some defects regarding payment
List
of.
on
Yes, my lord.
list on 9th February. Defects we removed in the middle.
My lord, one thing, my lord. So far as the nomenclature is concerned, my lord, I have an individual interest in this writ application. I have challenged, my lord, para 6 petition, my lord. I have filed this writ application challenging the illegality committed in the distribution of plots in a plotted scheme by Talcher Anugul Meramandal Development Authority, my lord. And we are the applicants and we are participant in the lottery, my lord. Because of the illegality committed by these authorities.
Are you now arguing the matter or you want to give
No, my
the
lord.
defects?
They have shown that it should be a writ petition. This writ petition is not maintainable and I have to change the nomenclature into PIL, my lord.
We don't know about that. Anyway.
Item 11.
Oh, by 9th, my lord.
Item 11.
May I please your lordship? In this matter, one defect is on 6 rupees not paid. May I submit this, my lord? Memo.
What's the matter about?
A matter relating to PIL, my lord. On villagers are filed before your lordship, my lord. Opposite party number 5, one private opposite party taken away leads in a government land and encroach the adjacent land so that the villagers cannot move properly. The road is closed, my lord. So that villagers repeatedly.
Petitioner's representation bracket and action. You see, counsel, the petitioner at the outset states that she has already deposited the deficit court fee. In that
Yes, my lord.
Petitioner's representation. shall be
Representation,
considered
my
by
lord.
the-
Representation pending.
1 minute, madam. Just listen to the order.
Yes, so obliged, my lord.
You don't just ask him to come back. Hey,
Sorry,
you
no.
file it in the registry.
Okay, my lord.
When we send him, he never goes. No, on his own, he starts walking. The petitioner's representation should be considered by the
My lord, maybe
Tahsildar. All right, Khaira. And after
District Baleshwar.
notice to the petitioners and opposite party number 5, and after giving them a hearing, a reasoned order should be passed not later than 10th April and communicated to parties within a week thereafter. The court clarifies it is not expressed legally.
Item number 12.
Obliged, my lord.
Your lordship, this is regard. My annexure is pending at page 43 that may be disposed of in lieu of prayer A and B, your lordship.
The representation of the chief secretary.
See, this is too broad a representations.
Yes, my lord.
Your
You have
lordship,
to have specific prayers.
in fact, your lordship, the 2 prayers, and I have annexed the acts as well
You have
as
to
the
be
rules,
very
your
specific.
lordship. Prayer number
These
A
are
and
not
B, your
matters for
lordship.
like this. You have to work harder, sir.
Lordship,
You have
it's
to work harder. You have to find specific instances, then point out. All right.
we have also sought for information under RTA.
This is not the forum for all that, sir. You have to do that homework. You do it.
Lordship. Lordship, may I pray at least housing and urban secretary may be directed because CMC and all municipal corporation and
Doing your
bodies.
homework, sir. This is not the way to file a petition. This is not the way to ask for reliefs.
He has given representation to all the authorities individually. How
Lordship,
can-
page 127, clause N says Lordship to facilitate preparation of food safety plans for panchayat and
See,
municipalities.
you have to be very specific in what you're asking. All right. Not all over Orissa, all over the country. Nothing will happen. You have to be very specific. You have to first do homework.
Lordship, it's not trust based in the district of Jagatsinghpur. May I pray?
See,
your
this is not a petition for publicizing your trust. All right. This is for seeking some specific remedy for a problem.
Lordship.
You have to be specific. You have to be specific where you want the problem to be resolved. Where is the problem, first of all, and how you want it to be resolved. You have to be clear in your mind, first of all. Counsel, the petitioner seeks leave to withdraw this petition with liberty to file a better petition with better particulars. Disposed of is withdrawn with liberty spread for.
Obliged.
Item number 13.
May I please your lordship? So regarding the adverse effect of the proposed extension of mines by the opposite party number 6 in a scheduled district, my lord, Sundargarh. Here, my lord, because of the long tenure of mining operation, now the groundwater level has gone below.
Then you go to the NGT, sir.
My lord, in this case,
Go to the NGT for this.
but in this case, I'm applying for approval of 6. Both the issues has already been addressed. He challenges the section 19 notification on the land acquisition
Let's
act.
go to the NGT, sir. Anyway,
And
we're not entering.
you have already decided. Minor directed in a similar case. Minor
Let me
directed
say,
is
if
the-
any cause of action is there, you
Yes.
may go to NGT. But
and NGT has already passed the order.
it is all.
Minor in a similar case, in WPC number 38637 of 2021, I was appearing. Minor directed the Law and Council appearing for the opposite party number 8, OCL India Limited, informs the court that the National Green Tribunal is already seized of the same issue and has called for a report.
Just give him a copy of that.
And in the
Council appearing on advance notice for opposite party number 6 states that the issues raised in the present petition already stands answered by the National Green Tribunal in an order dated
order to them. May 2000.
12th May 2022 in appeal number 5 of 2020 of the EZ. A copy thereof has been provided to counsel for the petitioner. If the petitioner is still aggrieved by any further aspect that requires to be addressed by the NGT, it will be open to the petitioner to approach the petitioners to approach the NGT. All right. All right. The petition is disposed of. All right.
Item number 14.
This is regarding encroachment of Gochara land, that is grazing ground of the villagers. And representation has been submitted by the annexure to
All
that
right.
running page.
Petitioner's representation shall be examined by the Tahsildar Atagad and after notice to the you're not made the encroachers parties, sir. You'll have to make a fresh representation. You can name the encroachers.
Well, several encroachers.
You're a designated senior advocate, sir. What's his name?
Several.
Sorry, man. Sorry. No, don't start doing it here. That is even worse. This is not the dressing room. Yeah. This is not a dressing room. All right. All right. Where is the name? Have you named the encroachers?
Several encroachers they will be enemy to us, my lords.
I know. That's how you have to take on your enemies, sir. You have to name them, take them on.
Several encroachers.
You have to unless you have to pick up some courage. You name them, sir. You name. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file fresh representations naming the alleged encroachers. And after following up on such a representation to seek appropriate remedies in accordance with law. Disposed of is withdrawn with liberty spread.
Item number 15. Item 15.
May I please your lordship? My lordship, one week time may be given for removal of the defect.
List on 3rd February. No, 3rd is holiday. Correct. Friday. List on 7th February. Defects be removed in the meanwhile.
Obliged.
Item number 16. Item 16.
Where for the opposite party, my lord, this last occasion it was listed before the Honorable Justice. We are studying a division bench. It's some PIL nature. That's why my lord has transferred the matter to my lord for education. It is a specific allegation against the Honorable Minister. And the government of
Mr. Padi, you're for the petitioner.
No, I am for the opposite party. You know.
Let's see who the petitioner is.
I am for the petition.
Yes.
I am for the petitioner.
Yes.
I am for the petitioner. Am I audible, sir? Am I audible?
Yes, please. Carry
For
on.
the petitioner, sir.
Yes.
Sir, my submission is that my son's 2021 exam will be started from 24th January 2023. Sir, I am a social activist and also advocate of your honorable court. My submission is that please look into page number 18, Annex 2. I have annexed my son's admit the card which has been put by the JEE in page 18 and in page 17. I've annexed that for the 108,665 teachers from all over India, I have demonstrated along with the victims, the teachers, in front of the minister's, Honorable Education Minister's house. And after continuing in page 16, they have the ministerial, they discussed with me on 23rd February 2022, and then the matter is over. At page 10, the NCR of all the teachers has been at page 10, the NCR is removed. And after that also there is some issue, and in page 11 it has been clarified directly to me by the NIOS, National Institute of Open Schooling, at page 11. In petition page number 4, at point number 3, I mentioned that in this, 21 cases. 21 cases is in this honorable court is the judgment has been go against in page number 5. The honorable judge on 23rd December it give judgment against the illegalities of the OP number 1. I am now being targeted. My minor child's bright future can be damaged. So sir, may I say, sir, am I audible?
You are audible, sir. You are audible, but our understanding is so limited. We are unable to understand anything that you are saying, sir. You have to pardon us. You are very clearly audible, but nothing which you are saying is understandable by us.
Sir,
we are reading your prayer. What you are arguing is not reflected in your prayer at all. Can you read your own prayer?
Sir, I pray for tomorrow, sir. I am sick today, sir. I want to appear before you tomorrow, sir. This is my son's career. So please, sir,
we have a request to make for you, sir. Can we request you something?
Sir.
No, can we request you to do something, sir?
Please, sir.
Kindly read the prayer clause, sir, in page 8 of your petition. You have your petition with you?
Sir.
Kindly read page 8, sir, of the prayer clause.
Sir. 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 Sir, it is therefore most strongly prayed that this honorable court be graciously pleased to admit the petition call for the record issue a writ in the nature of mandamus of or any other writs directions directing the OPs for video and audio recording of questions put up and answers given by Sansit Suman in JEE Main 2023 session 1 and 2 and advanced and 12th board examinations and depositing this video.
What is the meaning of this? What is the meaning of this? The 12th board exams will be held when? When are the 12th board exams to be held?
12th board exam will be held from 24th February of CBS.
So why should it be audio recorded and video recorded? How is audio recording of an exam? What is audio recording of somebody's exam? What is the meaning of that? What is the meaning of an audio recording of somebody writing down, sitting down quietly and writing exam? What is audio recording?
Sir, I'm just my son will give the question paper in the hall, and after that something happens.
Sir, we are not here to anticipate all the problems your son will face. This is not, you can't file petitions in court for all these things, sir. Sorry.
Because
don't waste the time of the court and don't abuse the process of law.
Sir, my son's career may be damaged by the
for all problems under the sun, the court is not the answer, sir. All right.
Sir, I've been also exposed to these petitions. Sir, please sanction some relief for my.
Since you claim to be an advocate yourself, sir, we are not equipped to advise you because you are very learned. You belong to a noble profession. Sir. So we are ill-equipped to advise you because you are knowledgeable in the law. Correct?
Sir.
So we are not able to entertain your petition, sir, because we think it is misconceived.
Sir, then, sir, if something happens, sir, the career of my son, because it cannot be overcome. If the career of
the prayer
my
in the present petition reads as under, reproduce that prayer 3. Having heard the petitioner who appears in person, the court considers the entire petition to be misconceived and premature. And in any event, the reliefs prayed for are incapable of being granted. The petition is accordingly dismissed.
Item number 17.
Lordship may reflect along with me, Mr. Jusna Sahu is appearing in this case.
Item 17.
My lord, I am appearing in person in this case. The matter relates to discharge of contaminated and polluted water to River Mahanadi.
NGT, sir, go to the NGT.
Well, a similar matter is item 60 today. Similar.
Then
matter.
let us not entertain more and more petitions.
Similar, this can be adjudicated here.
You say counsel the petitioner seeks leave to withdraw the present. You say petitioner who appears in person seeks leave to withdraw the petition to approach the National Green Tribunal in accordance with law.
My lord, may I praise me? But a similar issue.
So we don't need to multiply. If you say similar, then either way we will not entertain it, sir. Why should we multiply petitions?
I asked my learned senior. He said that this particular point is not raised in our petition. So you raise it.
Who is the senior, sir?
Who is the senior? Who told this?
One moment. Mr. Khirod Rao. He is in WPC number 2747/16.
We permit you to assist Mr. Khirod Rao, and we'll ask Khirod Rao to amend the petition to include this prayer.
That will be better.
You please do that. Counsel the petitioner seeks leave. The petitioner who appears in person seeks leave to withdraw the present petition with liberty to seek other appropriate remedies in accordance with law. Dispose of is withdrawn with liberty is paid for.
Item number 18.
Petitioners are poor farmers of the village Muribahal in the district of Balangir. They have represented to the opposite party number 3 without making de-reservation policy of the government land going to be constructed the government official such office building.
You have to remove defects. What happened? You say list on. List on 7th February, defects be removed in the meanwhile.
As the representation is dated 17/12, at least a month should be given before.
They don't wait. It's all one package. Draft the representation within 3 days. File the writ petition. That's it. Yes.
Item 19. Item number 19.
None appears for the petition. Dismissed.
Item number 20.
My lord, in this case, prayer, my lord, is at page 11, my lord. The honorable court may direct to opposite party to.
What are the defects, sir? There are 2 defects pointed out.
Defect is regarding Vokalatnama, my lord.
Set it all right, sir.
My lord, only prior to issue the certified copy of the books of accounts which were seized. That books of accounts will be noticed to produce before the audit. So simple prayer, my lord.
Prayer may be simple unless where's the other side?
I am
appearing, my lord. Yes, my lord. I am busy, my lord.
You're prepared to return the books of account?
My lord, I filed the counter.
No. Then we'll. You're taking the long route, Mr. Chimanka.
Not solved, my lord.
I filed the counter.
I have not been solved with any counter affidavit.
So he'll file counter, you will file rejoinder. What he will not get is books of account. We'll get all of this. He'll get all of this.
Okay, my lord.
First, you cure the defect, sir. We'll make it a longer route now.
My lord. Let me solve with the counter affidavit.
No. First, we have to issue notice, sir. Only then counter will come. For us to issue notice, you have to remove defect.
My lord.
So list on 9th February. Defects be removed in the meanwhile.
Item 21. Item 22.
Lordship, permit me to.
21. 21.
Same, sir. Your name will be prominently shown in both matters.
Okay, my lord. Thank you. Now I'm out of Cuttack, my lord.
Right. All right.
Item 22.
Your lordship may permit me to remove the defect.
All right. List on 9th February.
9th February.
Defects be removed in the meanwhile. All right.
Similar prior to lordship may pardon me is on item number 24 also.
24 also. All right.
Greatly obliged.
All right.
Item 23.
Made, please, my lords. My lords, this is a writ petition challenging this section
23, my lordship. I pass over. My senior is on the way. 23 and 24.
Whom are you for?
Mr. Siddharth Mahapatra.
So we are still at the stage of fully notice, sir.
Yes,
Notice
your lordships have passed. This is a petition challenging the section 148 proceedings, which is barred by limitations. So your lordships have kept similar matters on 28th of February. And
No, but we've already sent all of you away long ago.
No, this is on the ground of limitation, your lordships. These matters are pending on the ground of limitation and change of opinion, your lordships.
No, change of opinion. And I think you said all grounds can be raised at the appropriate stage.
But it is barred by limitation, your lordships. There are two.
Even that can be urged, sir, at the appropriate stage.
Let's say, if your lordship would pardon me, lords, I've come across a judgment of the Honorable Supreme Court, lords, where the Honorable Punjab Haryana High Court had dismissed the petition, saying that this 148 AD order is an intermediate stage.
Correct.
And you still have a 148.
Correct. And that is approved by the Supreme Court.
No, that is not approved.
Yes.
It's a great
Your lordships.
May I just share that to the orders?
All right.
That's, I'm sorry, Lord, for the.
No, please.
And also, I'm giving the orders which your lordships have passed and kept on 28th of February.
It's a very
Show
short
us all of that.
This order is of 3rd of January 2023, minutes.
23
minutes. May I just share that order?
Yes, please. This was before we passed that other order.
No, this was recently, my lord. The Punjab Haryana order was on 2nd of June 2022, my lords. May I just place it, my lords?
No, but what happened to that earlier? There's no reference to the.
There's no reference, my lord. But
to that order,
my lord, even in Punjab Haryana, my lord, there was no reference to the earlier Punjab Haryana High Court order.
No, but once there's a Supreme Court order,
this is also
no. Obviously, this council didn't bring it to the notice. See, there was nobody for the respondent. There's
But
nobody
they
for
have-
the respondent.
They have, my lord, may I just place, my lord, subject. Accordingly, we set aside the observations made by the High Court. It's in the middle of page 2, my lords. In the impugned judgment, observing that the writ petition would not be maintainable in view of alternative remedy, to clarify that this issue would be examined in depth by the High Court.
Even when it arises.
No, what?
So they're actually not interfering. Even
No, no. In fact, my lord, they have said.
48, not A, capital A.
No, there's a
It's
small.
not capital A matters.
No, that's it for 148A capital A matter.
No. So we do deem it open to examine this issue in the present case after having examined the notice.
No, here, my lord, the Punjab Haryana High Court may share that order of Punjab Haryana.
No, but what has ultimately happened in this, the court has not interfered.
No, my lord. There's a wrong recording, but they have done it, my lord, with great respect, my lord. Recording the opposite, the special petition is disposed of. We clarified, instead of dismissal, I think it should have been disposed of.
No, they're clear what they're writing.
No, my lord, what they have done is, my lord, they have dealt with the
Show us
finance.
that our detailed order. The detailed order that we passed in the other batch, you don't have that.
So that
that we have. Show us that income tax order.
also, your lordships, the order which I have passed on is pending. Your
See,
lordships.
the good lawyer will also pick up the order against himself.
Sir, we
Because good lawyer will know that the judge has some memory. Bad lawyer will assume judge has forgotten everything.
No, this is not the case.
I have a copy of that order. I can just share it with your lordship.
See, Mr. Kerr is always ready.
No,
he is the good lawyer.
No, I don't claim it. I don't claim
it. They have to. Sir,
I don't claim it.
Things, no, they have to learn from people.
This was a backup.
I'm serious.
Look,
See, I mean, that's what gives you the standing in the bar, because
this was a backup.
You will keep all the orders, whether it's for you or against you.
I'm sorry, my lord. I just have the certified copy. I've not made printouts.
It's all. Kailash Kedia. Correct. Kailash Kedia takes care of everything now.
Lordship may only read.
Sorry, your lordships.
See, this order which you showed us is 15th November.
Sir.
Since we are judges, we can change our minds because it's not a final judgment. By the time we reached 1st December, we were very clear. On 15th November, we were not so clear.
So in that case,
then all your colleagues, some very senior colleagues, Mr. Mishra on the other side, Mr. Satpathy, Mr. Mahapatra, everybody argued.
Your lordships, in that event.
Then it became very clear to us.
The new year, my lord, in my humble submission, made a fresh change to rethink.
I'm sorry, I thought this offered you a glimmer of hope.
My lord, that was the reason why, my lord, I picked it up.
You said you should notice, all they should have done is, this is why I think these people should not have jumped the gun. They should have let the department counsel be there to show Justice M.R. Shah's order. And then this bench may have said, we want to consider it and refer to a larger bench. Then all of you would have celebrated.
Honorable
Judge, every day we are searching away.
No, we are in the constant search, my lord, for finding out some avenue, my lord. Because your lordships have also opined, my lord, that this gives more room for the lawyers to keep on searching.
Yes. And this was an attempt made, but it's good. It's a good attempt.
Your lordships.
Sorry for disturbing your lordship midway, my lord.
We need to know all that's happening.
Your lordships, in that event, I may pray for an adjournment, your lordship, because your lordships, because in this matter, my senior from Calcutta will be appearing.
You're taking those chances, please.
Your lordships, then may pass over this matter at least, your lordships, please.
No.
It's a humble request.
Tactics are over now.
Just a passover, your lordships.
I should not be considered to be a red herring in
not honestly, your lordships.
Note this.
Senior from Calcutta will be appearing, so may pass over this matter, your lordships.
Sorry. There's nothing in this. No harm. We're only relegating you to an alternate. I mean, postponing your remedy. That's all. You see,
the lord should be trying to consider that Supreme Court, Lord, sir.
Yes, we'll refer to it. You see, as regards the intermediate challenge to an order under Section 148, capital A bracket D of the Income Tax Act 1961, at an intermediate stage, this court has, in its order dated 1st December 2022, in a batch of writ petitions, of which writ petition civil number 9191 of 2022 bracket Kailash Kedia versus Income Tax Officer bracket was the lead matter, declined to interfere, relegating the parties to a stage where the assessment order is passed under Section 148 of the Act. We'll stop. In doing so, this court followed the judgment dated, the order dated 2nd September 2022 of the Supreme Court of India in SLP Civil
86 of 2022. It's at the top right-hand column.
Right. That's right. 2nd June 2022 in CWP number. Sorry, where is the Supreme Court SLP?
No, that's at the top, my lord, right-hand
Right. 2nd September 2022 in SLP Civil 14823 of 2022, bracket Anshul Jain versus Principal Commissioner of Income Tax, which in turn affirmed the judgment dated 2nd June 2022 of the Division Bench of the Punjab and Haryana High Court in CWP number 10219 of 2022, bracket Anshul Jain versus Principal Commissioner of Income Tax.
I may be pardoned, Your Lordships, in this matter also, we have other grounds of change of opinion, which is a very settled law.
We'll permit you to raise all those, please, sir. Okay. The court's attention has been drawn to a subsequent order dated 3rd January 2023 of another bench of the Supreme Court of India, the composition of which is different from the bench which heard the aforementioned case in Anshul Jain Supra, where another order dated 2nd June 2022 of the High Court of Punjab and Haryana in CWP number 10073 of 2022, bracket Red Chili International Sales versus Income Tax Officer, bracket was challenged. So in the said SLP Civil 86 of 2023, the following order was passed by the Supreme Court of India on 3rd January 2023. Reproduce the entire order. Paragraph. As the court views it, although the aforementioned order did not take note of the order of the coordinate bench of the Supreme Court of India in Anshul Jain bracket Supra, the net result is that the Supreme Court of India declined to interfere with the order of the Punjab and Haryana High Court in Red Chili International Sales bracket Supra matter. Paragraph. Consequently, this court is not persuaded that it should interfere with the impugned order dated 24th November 2022 in the present case under section 148 capital A bracket D of the IT Act. Full stop. Counsel for the petitioner urges that apart from the ground that the notice under section 148 capital A bracket small b for Bombay of the Act was time barred, it is also hit by what he terms as single quotes change of opinion, unquote, of the assessing officer. Full stop. Needless to say, it will be open to the petitioner to raise all grounds available to the petitioner in accordance with law, including the above grounds, at the appropriate stage, as explained by this court in its order in Kailash Kedia bracket Supra. The petition is accordingly disposed of in the above terms. The interim order stands vacated. I think we'll make this also AFR. All right.
I am appearing for the deposit.
May I take back the certified copy?
Sorry?
May I take back the certified copy of your lordship's order?
Yes. He'll give it.
Lord, that will be a glimmer of hope, Lord. Just New Year's order.
Highly obliged.
All right.
I'm sorry, my lord, for interfering.
No, it's important, sir. Even for these youngsters, they should know how to come fully prepared. All right.
So I had similar matters which will be coming up before your lordships. I thought that will test it here.
One person who's going to be disappointed is Mr. Rai.
He's always on the job, my lord.
I know.
Innovate, my lords.
One minute. Typing it.
Obliged.
Right.
Item number 25.
May it please, my lords.
Yes.
Lordships, on behalf of Mr. Bharat Bhushan Rautre, my lords, Mr. Rautre is sick, my lords, and cannot make it to court. My lords, we just pray for one adjournment.
No. Anyway, there's a defect to cure.
In the meantime, we'll remove the defects.
List on 9th February, defects be cured.
Population.
Item 26.
Wait, please, my lord. My lord, appearing to work.
Yes.
My lord, 2 weeks time to rectify the defects, my lord.
All right, 9th February, defects be removed.
Obliged.
Item 27.
May I please, my lords. This is in fact a matter which is covered by a judgment of this Honorable Court. In the case of Durga Raman Patnaik versus Additional Commissioner, judgment is authored by my lord Honorable Justice Raman, my lords.
Okay.
The facts of the case is like this, my lords. Plus, by the Annexure 1, a so-called notice was issued, my lords, on the ground that investigation report was submitted and the investigating officer says that he wanted to contact the assessee, my lords. He rang up the assessee because he did not respond to the telephone call. On the ground of non-cooperation, he recommended rejection and the license was rejected. The GST registration was rejected, my lords. But against the cancellation order which I have annexed by Annexure 2, my lords, I filed appeal. Instead of my lords filing, as my lords knows, a revocation application that is also permissible. I could have filed revocation. I filed appeal, my lords, and belated appeal, my lords. It's a delayed appeal. And the judgment of your lordship says that revocation, now I am interested to file revocation, my lords. Your lordship said, set aside the appellate order and permitted the petition to file revocation and to also with a condition that I will file all returns and pay the tax.
There may be that COVID judgments should cover there.
616 days, even that covers beyond that also.
Here your appeal was dismissed on
21 days delay, my lords.
No, 30th December 20.
Oh, it is sorry, 6 months or less than 6 months. Yes, I have seen less than 6 months, and that is a case involving my lords in 616 days, my lords.
So you withdraw this petition with liberty to go for revocation in terms of this judgment?
And in same direction, in terms of that judgment, because your lordship have given some directions, I have to comply with, your lords. In paragraph 12 and 13.
He has to deposit all the taxes.
Yes,
So
yes.
that is in the statute, your lordship.
Yes.
In the statute, and your lordship has passed many orders. And he has to comply all these, all the provisions.
You have the shorter order we passed.
Your lordship, because the weaker order.
Or
Your lordship, in the launch.
She has.
In page 14, in fact, I don't have any dues. On their own saying, they say, for last 6 months, the returns which I filed, that was nil return. Only, I could have filed revocation, which I have not. Your lordship. Page 14 of the brief.
Section 30, putting the outer limit.
No, so far as 30 is outer limit is your lordship.
107 there is the outer limit, and now under 30 also they have brought. Should be aware.
For revocation, 30 days, my lord.
No, under section 30 there is an outer limit.
Outer limit, yes. A revocation, subject to such
No, you are holding a wrong book, old book. Now in 2021 there is an amendment.
Yes.
And even after that,
Your lordship.
that compilation,
Your lordship.
that has come into force.
And the new book also subject to
But it has already.
cancel proper officer on your own motion may apply to such officer for revocation of cancellation of the registration for the prescribed manner within 30 days from the date of service of cancellation order, provided that such period may on sufficient cause being shown and for reasons to record writing be extended.
Extended outer limit is
By the additional commissioner for not exceeding 30 years, by the commissioner not exceeding. So now, because of I have adopted a different route, I will withdraw that and I will comply with lordship direction by complying paying tax. There is no tax involvement.
All right.
I will comply.
The challenge in the present petition is to an order passed by the Joint Commissioner of State Tax Bracket Appeal, Territorial Range Puri, dismissing the petitioner's appeal against an order dated 8th December 2021, passed by the proper officer, that is Additional CT and GST Officer, Jatni Circle, Jatni, cancelling the registration of the petitioner under the OGST Act. Full stop. Mr. Sahul, senior counsel for the petitioner, has relied on the judgment of this court in Durga Raman Patnaik versus Additional Commissioner of GST, Manu OR 0909/2022, and submits that in the present case also, the petitioner will opt for filing an application for revocation of the cancellation by complying with all the other requirements of depositing all the taxes and penalty and interest due and other formalities as required by law. Stop. Accordingly, the following direction.
If payable belongs, because I have filed nil returns. If payable, because as per return
as payable, we say.
Yes, as payable.
Accordingly, the following directions are issued. Notwithstanding the impugned order dated 30th December 2022 of the Joint Commissioner and order dated 8/12/2021 of the proper officer, the petitioner is permitted to file a petition seeking revocation of the cancellation of registration, provided such application is filed not later than 30 days from today. 30 days from today. Or not later than 13th February 2023. Two, provided that the petitioner makes payment of all the tax, interest, penalty, fine, fee, etc. as may be payable. The above application will be entertained and an appropriate order passed thereon in accordance with law within a further period of 90 days. Full stop. It is made clear that the department would be at liberty to verify the veracity of the claim made in the returns. But after the revocation, it has to be. You say COVID time. Right. Correct.
Your Lordship, can I be permitted to argue one point, Your Lordship? Because this judgment was passed prior to that outer limit, Your Lordship. In this case, Your Lordship, Honorable Supreme Court is very clear that this judgment, Your Lordship, may kindly go through this judgment of Honorable Supreme Court larger bench judgment, because I have kept all these judgments to argue the next matter. The next matter has been dismissed on merit dismissed due to delay, Your Lordship. Your Lordship, in this matter, Your Lordship may kindly turn to this judgment of Honorable Supreme Court.
My
Honorable
friend
Supreme Court
is of an appeal provision.
Honorable Supreme Court.
That is different.
And latest judgments have also.
Your Lordship, because this is a three-judge bench judgment, and this question has been referred to this larger bench, that when there is an outer limit, whether the appellate authority, even whether the High Court.
COVID has changed a lot of things. All right.
No, let's
COVID has come in and changed a lot of things. That's why many of these orders have come in acknowledging that change.
These aspects, so far as that condonation of
this
delay
is all in a normal situation when everything is going.
So far as this.
Yeah. Yes.
Case periods.
You say after revocation of the cancellation of the registration, the petitioner will be permitted to file returns. And for that purpose, just copy this A to A here. The opposite party shall take suitable steps. And then repeat 5 also. And 6. Just take A to A. The petition is disposed of in the above terms.
Item 28.
Obliged, my lord.
This is what you're trying to argue.
So let's see.
No, let me submit this.
Yes.
Sorry.
Okay. Because this case, your lordship, this brief has been handed over to me yesterday at night 10 o'clock. So your lordship, I have prepared this much, whatever with me, your lordship, I could not find out the latest judgment in these cases, your lordship. So far as the condonation of delay, your lordship may admit this matter, I can file the counter, your lordship, because the tribunal is not there. Your lordship, only so far as that condonation of delay, when the issue is that when there is an outer limit in the statute, whether that section 5 of the Limitation Act is to be applied or not, that is the issue, your lordship.
Let him make a submission.
Your lordship.
I understand my friend's anxiety, Milords. Plus, after the judgment of the Honorable Apex Court in Singh Enterprises case, Milords, saying that in the case where, Milords, particularly referring to appellate provision, where there is provision for filing Milords original for 90 days and discretion granted the commissioner, appellate authority, to grant 30 days more time. So, Honorable Apex Court in that judgment said that keeping in mind this 90 plus 30 Milords, the commissioner has discretion up to 30 days. So therefore, beyond 30, he has no power to, even if the tribunal system has power to condone, even if there is more than 30 days, 2 months, 6 months, there is no such restriction imposed for the power, appellate power of the tribunal. But such a restriction is imposed by statute in so far as the power to condone delay in case of first appeal by the commissioner. That's Honorable Apex Court said one line, probably that has also been repeated in the case of judgment of our High Court, which I was arguing. That's the Joybala Jyoti Industries case, saying that otherwise, Honorable Apex Court has very carefully said, otherwise the reasons advanced by the appellant is not found acceptable. I therefore argued in that case, had the reasons for condonation of delay would have been acceptable, probably the Honorable Apex Court could have not allowed the prayer for condonation. So therefore, Honorable Apex Court dealt in two aspects. One is 1930. Discretion for which restriction is provided in statute, and going by the merits of the condonation application itself, Honorable Apex Court said that otherwise we don't find the reasons to be acceptable. That is why that condonation was not allowed. And recently, Karnataka High Court, I was just today morning only I found I couldn't prepare copies for lords. It was there here. Honorable Karnataka High Court says in under Article 226, in appropriate circumstances, where court feels.
So we'll issue notice that like what he's saying, let him file a reply.
Your lordship. Your lordship, I'm relying two judgments. Your lordship.
Wait, you file a reply, sir, will not.
Your lordship.
May I seek up lords? This is a case where the entire thing generates from section 74 order, Milords. That's what has happened. The very genesis of 74 order flows from the scrutiny under section 61. That's the very same genesis, Milords. Now, another parallel proceeding initiated by the proper officer under section 73. That's my lords may kindly see the consequences. Whereas scrutiny resulting in 74 have two different consequences. In 73, penalty is less, consequences are less. 74 Milords, as my lords knows, ingredient are fraud, collusion, willful misstatement. Those are the not like 73. So therefore, I am now. I was supposed to file a memo along with 73 parallel proceeding. Now I want to incorporate all by filing a fresh. Your lordship can permit me. I will refile a better application. That will
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a better petition, incorporating more details in accordance with law.
Deeply obliged.
Post of is withdrawn with liberty spread.
Orders item 29.
My lord, in item number 29, this writ petition has been filed regarding exemption of MGQ duty on account of closure of excise shop due to COVID crisis for the year 2021. My lord, government has not taken note of the weekly shutdown, weekly lockdown, home delivery in respect of country liquor shop. My lord, they have to answer that who takes home delivery in country liquor, my lord.
You're going before the commissioner or not?
No, my lord, so far as 2021 MGQ is concerned, I think no demand has been raised and it has...
my liability remains, my lord. I have not...
Next year it is shifted to. So
2021, they have... After that, they have...
Prayer is only to consider
my representation is pending, my lord.
It's only for that.
After 2021, they have gone for lottery, my lord.
Correct. The petitioner's representation to the excise commissioner shall be examined by the excise commissioner. And after giving a hearing to the petitioner on a date to be intimated to the petitioner at least 10 days in advance, a reasoned order shall be passed not later than 10th April 2023, and the order shall be made available to the petitioner within a week thereafter. Court clarifies it has not expressed any view in the matter.
My lord, what I pray is let I be protected, my lord.
For what?
No coercive action. Demand may be issued.
No, that whenever it's issued, then you can come. Yes.
Item 30.
Before the auction, this case was filed.
Item 30.
Item 30.
Infructuous.
All right. None appears to the petitioner. In any event, the court is informed that the petition has been rendered infructuous. It is dismissed as such.
Item 31.
My lord, item number 31, I pray for a passover, my lord.
All right.
Item 32.
May I please, Lord? And here the pursuant to public notice, but I have filed objection before the collector. And the collector, without considering my application, the superintendent excise recommended to the commissioner, and commissioner in the meantime has recommended to the government. But I have filed a representation before the government under Annexure 5. But that is pending, Lord.
No, but what happened to your objection? That was within time.
Yes, yes. It is within time. It is not considered. They have just stated it is a general in nature. They are not considered my grounds of objections, Lord.
Counsel
only one line
states that the objections filed by the petitioner on 5th December 2022 to the grant of a license for a new IMFL on restaurant shop at Sati Restaurant in Moza Ward number 4 of Usura NAC District Balangir was within time, and yet it was not properly considered by the collector.
No, right, by the government it will be, because it is now pending before the government. Government
it was not considered by the collector properly, so you want that should be
the collector who has made a recommendation for its grant to the government. Full stop. Admittedly, the matter is now pending before the government. Full stop. In that view of the matter, a limited direction is issued that while taking a final decision in the matter, the Secretary, Excise Department, Government of Orissa, will take note of the objections raised by the petitioner in Annexure 5 to the present petition, dated 5th December 2022, and pass an appropriate order in accordance with law.
I give you an opportunity of hearing.
No,
because we don't know the final authority.
Part
is the final authority. He should give me an opportunity of hearing, because Section 41 says, my lord. Section 41 says, Section 41 says that the government will consider without
no, hearing is not a mandatory thing. Not hearing. The decision of the government will be made known to the petitioner within a week of its being taken. All right. The court clarifies it has not expressed anything in the matter.
Obliged. Item number 33.
33, my lord, the appellant has already died, my lord.
All right. The state in the court is informed that the appellant has died, dismissed as having abated.
Obliged.
Item 34.
May I please, your lordship? Your lordship, on behalf of Sudeshchandra Das.
Matters.
Your lordship?
33.
Item number 34, your lordship.
33 too much.
30
W294 of 2015.
33, my lord, the appellant already died, my lord.
No, one matter. That is, there are two matters, sir.
One matter, my lord. 31 of 2015.
So in the other one, you say none appears to the appellant, dismissal, non-prosecution. All right.
34.
On behalf of Sudeshchandra Das, your lordship, kindly give 1 week time for filing the limitation petition, your lordship.
Not now, sir. It's already 7 years over now.
Milord,
the last 7 years.
Milord, sorry, I am sorry, Milord. Milord, I came, Milord. Milord, what happened, Milord? Milord, that regarding a limitation, Milord, I will take step within 7 days. I have filed recent certified copy recently as per your lordship's last direction, Milord. And from the date of filing till filing of certified copy, delay has been shown by the office, Milord.
Right.
Well, on that only, I will file the limitation petition within 7 days, Milord.
No. There's a delay of 2,513 days in filing the writ appeal. This writ appeal has been pending for the last 7 years, and yet no steps have been taken for limitation, for condoning the delay, despite the office having pointed out the defect more than 7 years ago. The court, in the circumstances, does not consider it appropriate to grant any further indulgence in the matter. The appeal is dismissed on the ground of limitation.
Milord, what happened, Milord? Actually, there is no delay in filing the appeal, Milord. because the certified copy was filed lately, my lord, that is why appeal has been shown from the date of filing till filing of certified copy. That is the delay pointed out by the office, my lord.
All
My lord, explaining that, my lord, I will only 2-3 days time, lords may give, my lord. With
Sorry,
regard
sir,
to this,
sorry.
my lord. My lord,
Item 35,
my lord,
Yes.
2-3 days time, my lord, I pray for, my lord.
Sorry, sir. Yes.
35.
None appears for the appellant. Dismiss for non-consideration.
Item number 36.
36, I prefer some time to remove the defect.
It's a 2018 matters. What's the delay? There's a delay of 1300 days preferring this appeal. The reasons provided in the application for condition of delay are both unconvincing and unsatisfactory. Consequently, the court is not inclined to condone the delay. The IA is dismissed. Consequently, the writ appeal is dismissed.
37.
May I please, your lordship? I pray, my lord, your lordship's order paragraph 10 may be modified, my lord. The order of paragraph 10, your lordship's directed that before the SO, the appellant is to be appeared by on today, my lord. But your lordship's in similar cases directed that the Tahsildar is to be done, is to do the direct comply the direction, because the SO is now the functus officio. She is having no papers with him to dispose of the lease matters. So I pray, my lord, paragraph 10, in place of SO, the Tahsildar may be directed.
What's the position?
And that's the basis of the single judge's order was that since the ASO becomes functus officio after Miller's publication of the final ROR, therefore Miller's he couldn't proceed. The writ appeal, the basis of the writ appeal was that no notice was given to them, and then thereafter Miller's
No. His point is in the SO is no longer dealing with the matters. It's Tahsildar. Is it right?
Yes, my lords, in other petitions, in other writ appeals, my lords have directed that the Tahsildar to deal with
the application. For the reason stated, the application is allowed. The authority before whom the appellants will now appear will not be the SO bracket who is stated to have become functus officio, but the Tahsildar. The date for the appellants to appear is postponed to 6th February 2023. No further modifications are called for. The applications are disposed of. You put on all the applications together.
Actually, now in Bhubaneswar, the settlement records are already transmitted to Tahsil.
All right.
All
The 6th February, let them appear.
Yeah.
All right.
All other 37 to
49.
Yes. Just put down all the numbers together. Right.
Obliged, man.
Item number 50.
Delay. 124. None appears to the appellant. Oh, you're there? Who's there? This is states.
Item 50.
All these matters, Lord, relates to the case of Sarat Parida. Similar case has been admitted by your lordship in the division bench. I am giving the copy, my lord. Batch of writ appeals have been filed. This is with regard to block grant institution. They are claiming pensionary benefit, my lord. As for the decision rendered in the case of Sarat Parida's case, a batch of writ appeals have been filed.
There were some other matters, Mr. Kuntia, same
No,
that first day hearing. It's a notice on the writ appeal as well as the IA for delay. Return of the 4th May.
51.
All other matters are identical
Or
to
51, 52.
item 54, my lord.
53, 54. Right. Same.
Operation of the order may be stayed, my lord.
Is there a contempt petition? Is there a contempt petition?
In many cases, contempt petitions are being filed at the instance of the petitioner.
In these have contempt petitions been filed? Say notice on stay as well. All right.
Item number 55.
My lord.
55. 55.
None appears for the appellate. Dismissal not.
Item number 56.
56.
56.
In item 56, my lord. We
56,
have-
my lord, the chief secretary has given a reasonable decision.
The minutes I have
Reasonable
filed-
order is passed, but my lord, my problem is we are not invited to that meeting.
You are not invited?
No. But resolution is reasonable.
It was not bookmarked.
Virtually, ASI is not taking steps as required.
Yes, Mr. Paddy, who's appearing? Where's Mr. Paddy? Mr. Paddy?
Well, let them grant some times to be take instruction, Miller, last chance.
Quota. Union bank. For union.
ASI may be directed to take these actions immediately and.
My lord, may I suggest one thing to you? It's long pending. Now the grievance of the petition is mitigated by order of the chief secretary, and my learned senior is also agreeable to this. Your lordship may dispose of the writ petition by saying these minutes of the meeting may be taken care of and necessary arrangement or that minutes, and I have given the.
Till then, your lordship may, the decision may be
all right.
Awaited.
An affidavit has been filed by the superintending
If
archaeologist.
they dispose of, they will not take action.
No, they will take. They will take.
Archaeological Survey of India, Bhubaneswar Circle.
ASI is not taking action.
On 24th December 2021. Placing in record. Where is the decision of Chief Secretary? Minutes?
Pardon me?
Which minute? Annexure what? To this
Page annexure A by 5 of my affidavit dated 5th January 2023.
Page 4, my lord.
Sorry, sir.
Page 4.
Page 3 and 4.
Filed by the
4 is
Superintendent Odisha State Archaeology.
What to be done? 1, 2, 3,
That
4.
affidavit is not there. This is 18 July.
Kali paile muba. Kali dele. Kali.
Should I give the hard copy?
January 2023, enclosing minutes of the meeting convened by the Chief Secretary on 20th October 2022, indicating setting out the decisions taken at the joint meeting as under. Take from page 4 of the affidavit, internal page 2 of the minutes, and 1, 2, 3, and 4. Paragraph. In that view of the matter, a direction is issued to the parties to adhere to the above decisions and take steps accordingly in a time-bound manner. Full stop. As indicated, time-bound manner at full stop. The entire exercise be completed within a period of 6 months.
Yes, ma'am.
My lord.
From today.
Where obliged?
Full stop.
Where obliged, my lord?
All right.
My lord may write one thing. The ASI may be directed to cooperate with the.
Yes.
Yeah, all the parties will cooperate with each other
Not
in
cooperating.
ensuring that the above decisions are implemented both in letter and spirit. Yeah.
Yes,
The petition is disposed of.
Decide to apply, direction is made.
All parties will cooperate. Sir. That's what you said. All right.
It's okay.
I have filed an intervention application. In this case, I have filed an intervention application. That intervention application has not come. Therefore, my application is that we are the Mahabir Nagar Development Committee, comprises 450 families who are residing there. all are, my lords, all the lands are our, my lords. We are the right title holder of the entire property. So we may be given opportunity, my lords, at least before taking an action against us.
It's all, there's no application, sir. It's not come on board. So.
Any individual cause can be raised. Any individual cause can be raised.
Can be raised.
Also.
That opportunity.
That
for the chief secretary. Yes, that opportunity we can be given, madam.
No. There's no application, sir. We can't pass this on.
So I have filed my IN number 360 of 2023.
Not before us, sir.
But
Yes.
that application has not come.
Yes.
Yesterday I have filed words.
All right.
Item number 57.
At least given opportunity, my lord, grant opportunity to.
So without that application, we can't pass on this. Right. Item 57.
Item 57.
This from the last occasion, Lordship. On the last occasion, on 14th July, Lordship had directed whether in East India Minerals case, my lord, passed by the Law Tribunal, whether that has been challenged before any other appellate forum or not, my lord. I have received the instruction, my lord, that has not been challenged.
Then.
May I please, my lord, in between another development has taken place. The assessee has filed a MA before the ITAT. There are certain grounds he has taken which was not adjudicated. So he filed a MA. In the MA, they recalled the order, and on the very same issue, they have allowed amortization under section 35E. In fact, the assessee claimed three things. Either it should be a revenue expenditure under section 37 or depreciation under section 32 or amortization under section 35E. So they have allowed.
He will file the affidavit and place an order.
Yes, ma'am. I will be placing those
appellate
orders.
states that he will file a supplementary affidavit, placing and record the subsequent orders of the ITAT. It's permitted to do so within 4 weeks. List on 1st May.
Obliged, ma'am.
All three matters. All the matters, sir.
Item 58.
My lord, item number 58, Mr. Das, his son had a brain stroke and is admitted in Australia.
No, you are for the petitioner.
Opposite party 12.
1 minute, sir. Let the petitioner appear.
Sorry.
Yes. Who's for the petitioner?
Nobody. 58.
None appears for the petitioner. Dismissal not possible.
Item 59.
59, ma'am, please, my lord. Is a public interest litigation, my lord. The petitioner are agreed because of the government land has been encroached. The land is recorded in the name of municipality and a kisam is non-jury. Non-jury is a reserve kisam of land and is objectionable. The opposite party, private opposite party, my lord.
All right. Petitioner's representation.
My lord, I'm for OP 5.6.
All right.
The private opposite party.
The petitioner's representation, bracket annexure 2 series, will be examined by the Tahsildar Katak Sardar and after notice to the petitioners.
After hearing you, Tahsildar will take care of your interest.
And opposite parties 5 and 6. A reasoned order shall be passed not later than 17th April and be made available to the parties within a week thereafter. The court clarifies it is not expressed anything in the matter. The petition is disposed of.
Supplementary list, item 60.
This is a PIL matter, my lord. Matter relates to non-availability of safe drinking water to the people in some parts of the state. This matter, my lord, appears to the release as per order number 33, my lord, dated 22nd November, my lord.
Who's for what co?
My lords, we have already filed our counter my affidavit on 6th January, my lords. On the last 5 days, we have already filed our so-called, it has not come to the record, my lords. And we have also served a copy to the petitioner, my lords.
All right. The affidavit dated 6 January 2023 stated to have been filed by Watco. Be placed on record.
My lord, petitioner has also filed a rejoinder.
The rejoinder of the petitioner to the said affidavit also be placed on record.
Kindly allow 1 week time for filing further affidavit on behalf of Barampur Municipal Corporation.
Council appearing for Barampur Municipal Corporation seeks and is granted 4 more weeks to file an affidavit. What about does one more person want to file an affidavit apart from Watco? CMC, is it?
My lord, CMC has not yet filed any affidavit.
Who's for
CMC,
CMC?
my lord.
Mr. Devashish Nayak should be there.
No, it's perhaps not.
The affidavit to the CMC also be filed.
Kindly
with the
give
same
some
date.
time.
Right.
Last opportunity should be given, my
Purpose
lord.
there.
Very important matter, man.
Second.
16th March.
My lord, 15 months.
16th March.
16th March.
My lord. Is it my lord covered matter? Man. By the Supreme Court.
Item number 61.
In this matter, your lordships are directed on the last occasion.
In item,
Examined to file an
in
affidavit.
item 61, your lordship has directed me to file an affidavit. My lord, I sought one short adjournment. Your lordship may call this matter on Monday. I will file affidavit by that date.
Mr. Kuntia states that affidavit will be possibly filed by the state on or before 13th February 2023. List on 22nd February.
Item number 62.
Item number 62, as a matter of last opportunity, was granted to file counter on 13th October.
My lord. Yes, yes.
It's a.
I humbly request your lordship may kindly give it. One.
Now that is going to be standard order now.
No, that is
No. If you file in time, you don't have to pay
No,
anything.
it is becoming a very.
No, that is how it all gets filed.
No, this is my undertaking. If your lordship will.
That's what we'll record that if you fail in that undertaking.
One thing I may be permitted to submit. This is my undertaking before the honorable court. If on the next day we will not file the counter affidavit,
we'll give you a
in
day.
spite of the fact that there is no order, we will deposit the cost of rupees 25. Although that is, your lordship may kindly believe me once, your lordship may not pass any order. Your lordship may grant me 4 weeks time. If on the next date I am unable to file the counter affidavit, I will deposit the cost.
Should we record that?
That recording, I don't. That your lordship has a tremendous memory, and your lordship can remember everything. So at least, and everything is recorded here, even if it is not recorded in the order sheet, but it is recorded in the
live
camera.
So D.K. Mohanty undertakes that the affidavit of the state will be filed positively on or before 20th February
20th February. Obliged, my lord.
2023. Rejoinder there to be filed before the next date. Good. 13th March.
Obliged. Item number 63.
May please, Your Lordship. Your Lordship, this matter challenges the enrollment fees for the Bar Council. We are filing the rejoinder today. Your Lordship.
Look. 63. Union.
A rejoinder has been handed over in court today. List for hearing on. April.
Item 64.
Item 64, may pray, this may be taken up some other day. I don't have the file. Lordship may kindly pardon me.
It's unserved notice returned from opposite party number 7.
I was unable to get my file today in the morning, so.
No, but even opposite party number 7 has not been served. What's the matter about it?
As far as I remember, Lord, my records are with the Vigilance Department. The sales tax authorities are called. I'll see the records, Lord. Your Lordship may grant me some time. I'll just go through.
Well, I am appearing for the Vigilance Department, OP number 5.
No coercive action shall be taken against the petitioner.
A short adjournment. If I don't have the file, I'll take the copies from the court.
Why was opposite party number 7 implemented and they've not been served?
The documents have been seized from his custody.
Who's custody of opposite party number 7?
7.
Yes. Well, petitioner has made an agreement, power of attorney in favor of OP number 7. So OP number 7 was executing the mine illegally. Now it is a case pending before the special judge Kenjor Vigilance. And 29 accused persons, including the petitioners, are facing trial, my lord. Under various offences. It is a scam of about 1,600 crores.
Oh, I see.
Lost to the state government.
All right. What you do is just give a hard copy. We'll pass it over, sir. Just go over it.
Lord, as far as I remember, Lord.
No, you take the paper book, sir. Why argue for memory? We're giving you the paper book. We'll pass it over, you come back. Pass over. Right. Yes.
Item number 65.
My lord, in this case,
yes,
your lordship was pleased to issue notice on 3/3/2016, my lords.
Yes.
And by rigid order on 11/3/2016, your lordship extended interim protection, lord.
Yes.
That's one copy of the order I'm handing over to your lordship. Two matters are there in the entity tax matter, my lords, which is, my lords, offshoot of this, my lords. Your lordship directed my friend wanted to file counter affidavit, and your lordship permitted him at last chance to file counter affidavit. In this case, also same order passed and matter. I will respond to that, and thereafter matter can decide.
All right, as a last opportunity, reply be filed within 8 weeks. And reply be filed on or before 1st March 2023. Rejoinder be filed before the next date. List along with Reproduction Civil 1974 of 2016 on 26th April. Interim order to continue.
Diplomacy.
Item 66.
None appears dismissed.
Item number 67.
My lord, 67. Yes, of automobile is covered, my lord. Till my lord.
Till 30th September.
30th September. My similar order.
This is the period is 1/4/2014 to 31st March 2017. So your lordship, after 30th September 2015, there are 2 years, your lordship. Your lordship might direct the petitioner to file appeal.
No, my lord. No, I'm not saying that. Please,
I'm not saying, I'm saying similar order may pass, but your lordship may direct after passing of the assessment, you come.
No, we have said appropriate remedies. Said appropriate remedies. Same order. All right. Same order.
Item number 68. 68.
None appears dismissed.
Item number 69.
May I please? Similar order may be passed.
What similar order? Harish Chandra Maji. All right.
No 70.
70, my lord. Lordship are directed to file an affidavit in this case, clarifying the position. My lord, that could not have filed a slot that next week be given. I will be filing counter affidavit in this case.
And the request to Mr. Mahapatra needs some more time. File the additional affidavit. List on 8th May, the affidavit positively be filed.
Obliged.
On or before 30th April.
Obliged.
Item 71.
My lords, in view of the developments in counter, my lords, amendment is required to the prior portion of the petition, my lords. I may be given 1 week time to file amendment application.
Then your lordship again have to file a counter.
Yes. My lords, here is a case, my lords. It is covered by 2 judgments of Telangana High Court and Gujarat High Court, my lords. Though OA bill was procured, my lords, it was not accepted by them. And CBDT circular says that even SMS message should be accepted, my lords. And the GST, IGST, everything is paid. Now they come with penalty.
And all that is appealable, right?
My lords, on the face of
got back
record,
the truck.
my lords, kindly see on the face of record, my lords, without jurisdiction, the proper officer verified the.
So that all that you take an appeal.
My lords.
Now you've got back the truck, I think.
My lords, it was by intervention of my lords.
So that is over.
It was released.
The purpose served.
My lords, I'll amend and I'll show that without jurisdiction, my lords.
That is the appellate authority, sir.
My lords, your lordship may allow me to amend.
Not necessary, sir, not necessary.
My lords, now it was paid, my lords.
Yes.
On the face of it, my lords, kindly see, my lords.
Yes.
For a moment, my lords.
Yes.
Page 20, my lords.
Yes.
My lords, turn to page 20, my lords.
Yes.
The EOA bill, my lords. It was generated on 4th, my lords, kindly see.
Yes.
4th January, my lords.
Yes.
At 9:30, my lords.
Right.
The inspection was made by the proper officer on 6th, my lords.
Right.
And the reason for detention was given that EOA bill is not there. Only ground, my lords. That your lordship kindly see. On the face of it, your lords, such a illegality is.
Yes.
My lords. With page 13, your lordship kindly talk. Page 13, my lords. The reason is given in the column, my lords. EOA bill not tendered for the goods in movement, my lords. It was dated 6 January, my lords. My lords, page 20, your lordship will find on the face of record, my lords, it was generated on 4/1/2021. Such action should not be encouraged, my lords. Yeah, on the face of it, my lords.
No, let's see.
And CPDT circular says even SMS message, if there is, they should allow EOA bills.
Your Lordship, at counter page 29, Your Lordship, the truck has been intercepted on 4th January 2021 at 7:30 p.m. Your Lordship, the waybill has been generated on 6th January.
4th January?
Your Lordship, the waybill relates said consignment has been generated at 9:31 p.m. So 7:30 p.m. this has been intercepted, and at 9:30 p.m. this has been generated, Your Lordship.
No. Now the vehicle has been released to
Your
him.
Lordship.
What is remaining to be adjudicated is there an order passed?
Your Lordship, so far as the levy of penalty, order has been passed, Your Lordship.
Where is that?
Your Lordship, that is that.
In their counter, they have given.
Your Lordship, that is that.
Page 13 of counter, they have given. And the reason is that waybill is not there. Though it was there.
Page 12, page 39, running page at 39. And the operative order is at page 40.
Against the impugned order of tax and demand, tax and penalty, admittedly, an appeal is the remedy of an appeal is available to the petitioner. Paragraph permitting the petitioner to file such an appeal and raise all the issues, all the points urged in the present petition, including any other points that the petitioner may have in accordance with law. This court declines to interfere further at this stage. If the appeal is filed, whom it has to be filed before whom? Against this demand notice?
Before Your Lordship, the Joint Commissioner appeal.
Before the appropriate appellate authority.
Your Lordship.
Under the statute in question. Not later than 13th February 2023, accompanied by an application for continuation of delay explaining the delay on account of the pendency of the present petition. It will be considered by the appellate authority in accordance with law. Full stop. The court clarifies it has not expressed any view in the matter. It will be open to the appellant, petitioner, if agreed by the order in appeal, to seek appropriate remedies thereafter in accordance with it. The petition is disposed of.
Yes.
Item 72.
Instructions to appear in this case.
In item 72, I need some more time to file the counter affidavit.
Final option to file counter affidavit within 8 weeks to join up to the next date. Interim order to continue. list on 15th May.
Your Lordship, Mr. Tushar Satpathy name may be deleted.
All right.
My name may be kindly
The name of Mr.
Tushar
Satpathy be deleted. The name of C.H. Satyajit Mishra be indicated.
No, my lord, I am appearing for the department.
Oh,
My name may
Mr.
kindly
Mr. Karas, R.P. Karas name be indicated. All right, for the petitioner. Sorry, sir.
Item number 73.
Nana, please.
Here the demand is under challenge, my lord. Lordship is directing the commissioner to approach. 73, 77, both are same. I've given two orders.
All right, same orders. All right, sir.
Interim order is there, interim order to continue. It is there also.
All right. All right.
77, same.
All right, same 77.
Item number 74.
74, my lord, infructuous.
Infructuous disposed of. Right.
Item 75.
Memos taken at record. Infructuous disposed of.
Item number 76.
Item 76, my lord, is infructuous.
Infructuous disposed of.
Item 77.
Already
77 already.
Same
Sorry.
order.
Same.
Item 78.
78, my lord, the state is not filed counter, my
My
lord.
lord, last chance maybe.
Last option file.
My lord, a similar matter is posted to 2nd May.
8 weeks rejoined to the next date.
25th January, my lord.
No, 2nd May, another same time.
List on 2nd May along with repetition civil.
No, along with that will.
List on 2nd May. Is there an interim order?
No, there is no. My lord, it is a running shop.
Oh, yes.
And he is saying that it is for last 1 year it is running.
Has been fixed to 25th January.
That's okay.
By March, my lord,
By that day, he won't be able to file affidavit. Don't worry. Yes.
Item number 79.
79, my lord, is a consolidation matter, my lord. Fragmentation is covered by my lord's individual bench decision. Last date, my lord, I argued that matter. I refer to the decision of my lords already laid down that law of my lords confirming that earlier division bench decision and single bench decision. My lords have stated last date, my lords stated my learned friend to take instruction whether it is covered by this or decision. 2022, 1 CLR 1132, my lords.
Mr. Mahapatra states that the matter stands covered in favor of the petitioner by the judgment of the in
my lords.
Just give us the book.
My lord, in this case, my lord, I am appearing for the opposite parties, my lord.
What is your stand? Is it covered by this judgment?
My lord,
Akshay Kumar Mohanty versus Pramod Kumar Padhiyari, 2022, 1 CLR 1132.
My lord, in that, I collect that decision from my lord and senior counsel.
Opposite parties needs time to examine it and make submissions. Interim order to continue. List on.
My primalers. The man is of
July.
The man is of age to 83.
Any interim orders there, sir?
83 minors expecting some justice, minors. So
31st July. All right.
31st July, minors.
Right. Interim order to continue.
Interim order minors, in fact, minors, any minors that minors have already fixed it up, minors. I pray a little bit earlier, minors.
What?
Only considering the age of that old man, that the moment he comes, minors.
All right. 27 June. After vacation, you'll all be refreshed. All right.
7th June.
27 June.
Item number 80.
May it please your lordship, my lord. Though, my lord, it is said the respondent number 1 is dead, my lord. The notice could not be issued on him. And he is the contesting respondent and she was the writ petitioner. But I think, my lord, this writ appeal can be disposed of, my lord. Now, what the respondent number 1 really prayed for before this honorable court, for, my lord, only a part of land, my lord. If that had been allowed, my lord, there is no problem. Now the entire land has been, in the writ petition, the entire land has been given. He wanted only 7 decibel, but by dismissal of the writ application, allowing writ application, 14 decibel given.
So if at all his prayer as per the writ petition is allowed, we have nothing to say. I have quoted the prayer in the writ petition.
No. What happens? He is dead. You have to bring on record his LRs then.
Sorry, Malad?
If you're still maintaining the writ appeal,
yes,
then you have to bring on record the LRs of the respondent.
Come on, that's right. Then I'll. But otherwise, if we had succeeded, Malad, what I'm saying is, otherwise it would be delayed. Nothing else, Malad.
No. If you're saying it is infructuous, dispose it of.
No, not infructuous.
But any modification
notice to the
without
respondent has been
Yes,
returned
of course.
with remarks, single quotes expired, unquote. Counsel for the appellant seeks leave, seeks and is permitted to file an appropriate application to bring on record the legal representatives of the respondent. So you file that application in the meanwhile, sir?
Yes, I'll Malad.
29th March.
Item number 81.
81, my lord, item has become infructuous.
All right. Disposed of is infructuous.
Item number 82.
82 also, Lordship. In the meantime, they have completed the project, Lordship. So
all right. Counsel for the appellant states that due to subsequent developments, the appellee has been rendered infructuous. This is disposed.
Item number 83.
None appears for the appellant. Dismissed.
Item number 85.
Delay. Notice has been served.
Lordship, page 7.
SLP is still pending.
Yes. Yes.
All right. Especially petition stated to be still pending. Interim order to continue. List on 31st July.
Supplementary list passed or matter. Item number 2.
May I please, Your Lordship? My Lord, may I be permitted to conduct the case on behalf of Mr. Senapati, my Lord?
Yes.
Here, the petitioners, my Lord, are the villagers of Dakhinora village, my Lord. And the very concept, my Lord, here is of Adarsh Vidyalaya. And the entire cause of action of my PIL is the construction of Adarsh Vidyalaya. Now, my Lord, the state government decided to establish 314 Adarsh Vidyalayas throughout the state, my Lord. Out of which every district, there will be, in every block, there will be one Adarsh Vidyalaya. And the present cause of action emanates from Adarsh Vidyalaya at Baleswar under block Simulia. And the name is Dakhinora. But, my Lord, they have, now what have they done is, instead of actually finding a site and starting construction at Dakhinora, which is a village also, they have found another site in different village, which is not centrally located, my Lord. Not only that, my Lord, even, my Lord, may I place, my Lord, Annexure 2 for a moment, my Lord. The committee which actually sat for site selection, my Lord, they never took into consideration also why a site would not be, why a construction of the building, the education facility will not be at Dakhinora. But straight away, on the instruction of the Tahsildar, they decided to construct the education facility at a different village, a village named Rampo.
Anyway, your representation is still pending.
Sorry, my Lord.
There's a representation of yours, 24th August 21.
Yes, my Lord. Annexure 4, my Lord.
We'll ask them to examine it. Say the petitioner's representation dated 24th August 2021. Shall be examined by?
What I beg to pray, my Lord, in the meantime, I have obtained instruction from the ADO Baleswar. I have instructed that building construction has already been completed, my Lord.
No, my Lord, what my
construction work has already been completed.
My instruction is...
He has sent photograph to my WhatsApp.
Let them file an affidavit because my instruction is they have only dug up that area for construction.
No, he says they've completed. Counsel appearing for the Opposite party number 2.
Mr. Mahapatra. Opposite party number 2, school and mass education.
Yes, my lord. School and mass, my lord.
For the standing council appearing for the school and mass education informs the court that the building of the Odisha Adarsh Vidyalaya at
Dakkinoda, my lord.
Dakkinoda village is almost complete. He states he'll place the details on record by way of an affidavit within 2 weeks with an advance copy to consider the petitioner who is permitted to respond thereto before the next date. 20th March, 20 March.
Item number 3.
I pledge your lordship. My lord, I have a prayer before this honorable court for formation of a special investigation team to look into the mismanagement in the Baripada Debotar property, my lord.
Baripada?
Debotar. Baripada endowments, my lord. Lordship may come to page 14. It's a inquiry report submitted, which we have received through RTA, my lord.
Center representation, right?
Yes, my lord.
The petitioner's representation, bracket annexure 2, shall be examined by the commissioner, endowments.
No, my lord. It's the chief secretary because under section 76, the state government is the appropriate party.
Chief secretary is to
because
he has got several. No, he can.
Under section 76, the state government is empowered to make any rules.
No, if the commissioner of endowment will examine it, if the prayer is found to be genuine, he will refer it to government for fixation of any SIT or so. That should be the best method of.
Because my lord, the commissioner of endowment office in itself is helpless because the report
then
reveals that around
commissioner himself is a senior judicial officer. He will examine the matter. If he feels that there is some genuineness in the grievance of he will refer it to the government for fixation of SIT. That's all.
Because my lord, it will take a huge amount of time.
More than 40 times, sir. It can't happen overnight. You see, the petitioner's representation dated 4th November 2022, bracket annexure 2, shall be examined with the commissioner of endowments. And after notice to the petitioner as well as the opposite parties, 5 and 6, a reasoned order shall be passed not later than 17th April 2023 and be made available to the parties within a week thereafter. No further directions are called for at this stage. The petition is disposed of.
Pastor matter item 31.
31, come on.
Lord, kindly turn to page 10, annexure 1. Lordship will find the order passed by the collector here directing closure of the sub beyond 3 days period. If your Lordship sees section 21, it is qualified by 3 provisions, 3 preconditions. 26, Lord, is qualified by 3 preconditions. 1, collector must give me a notice. 2, if the closure is beyond 3 days, he must take approval from the commissioner. Lord, 3rd, there has to be a report from the police. If a Lordship sees the order, this doesn't stand scrutiny of section 26, my lord. Without any prior notice, he straightway directs closure of my shop, and till it is shifted, means beyond period of 3 days, he has not taken approval from the commissioner. Lord, completely error of jurisdiction. Check.
Notice has gone in this or not yet?
Lord, notice has not gone, but my shop is closed because of this. I am liable to pay.
I know, but he still notice has to go.
State Lord has to accept notice.
That's right. Notice.
I will take notice. I will take notice.
Mr. Monty accepts notice on behalf of the opposite parties. The reply will be filed within 8 weeks, resorted for the next date. List on 16th May.
Lord, I pray stay of this order. Lord.
Till then, the impugned order shall remain stayed.
Grateful.
My lord, it is order is dated 12th December.
Right.
So it must have been implemented. The shop must be closed.
Lord, I'm saying to them only.
I'm saying something which will be which can be worked out. Because unless your lordship will pass an order that the shop will be allowed to be operative, then stay order will not, because this order has already been implemented. You should pray for an interim order that we may be allowed to operate this shop, because the shop must have been stopped. That what I understand from Annexure 1 itself. 12th December, the direction is, if no, my friend is saying that in spite of...
He's still running the shop.
Yes.
If Mr. Obviously it has to be closed. Like if Mr. Mahanti is interested in closure,
Then
No.
I have nothing.
So what is the interim order to the effect? What
Not if the order is stayed, well, obviously I'll try to open my shop.
As your lordship likes.
All right. No coercive steps to be taken against the petitioner till the next date. All right.
Item 64.
My lord, date is fixed.
16th May.
But I have checked up, Lord. This matter, Lord, has nothing to do with that scam. Lord, here is a case, Lord, where opposite party number 7 is my power of attorney holder who was looking after it. He has committed some fraud and he has committed some scam for which the Vigilance Department is. And they have seized all the records, including my records from the mines. In the meantime, the sales tax department raised a demand. I approached the authorities that you give me those papers because I have to present them. They did not. So they have passed the assessment order. I have summed up my submission at.
But you can always challenge the assessment order.
Lord, what I have said that I am in such a plight that I cannot prefer appeal also because I have no records. All the records are with the Vigilance Department. So what I pray, Lord, let them give in. I undertake to return them for a specific period so that I can.
No, you can inspect it. You can allow the inspection of the vigilance to record in vigilance.
Your Lordship, it is since the assessment order.
During the pendency of the present petition, an assessment order under the OVAT Act.
Not pendency, Your Lordship. This assessment order has been challenged in this state petition.
Oh,
yes.
All right.
Your Lordship, that is
Annexure 1.
The challenge in the present petition is to an assessment order under the Orissa Value Added Tax Act.
43, under section 43.
Section 43 of the OVAT Act. Counsel for the petitioner states that the petitioner is not in a position to file an appeal against the said order since the documents are not available with the petitioner. Full stop. These documents were apparently seized by the Vigilance Department. From the premises of opposite party number 7, who has opposite party number 7, the notice upon whom has been returned unserved without any report. Paragraph, be that as it may, since the petitioner is seeking to have access to the documents seized by the Vigilance Department, it's directed that the petitioner will be permitted to inspect the said record in the office of the Vigilance Department.
Vigilance.
Well, provided it is available in the department, because the case is pending. So I hope it must have been produced before the Vigilance Court.
That is the Deputy Superintendent of Police, Vigilance Cell, Vigilance Directorate, Cantonment Road, Cuttack. In case the record is available within the next 2 weeks on a mutually convenient date, which will be communicated to the petitioner at least 5 days in advance. Full stop. 2, the petitioner will then avail of the appellate remedy. And if the appeal is filed not later than 1st March 2023, accompanied by an application for condemnation of delay explaining the delay on account of the pendency of the present petition, it will be considered in accordance with law by the appellate authority. The court clarifies that it did not express any view of the matter. Paragraph. The interim order passed by this court is vacated. The petitions disposed of the above terms.
We'll continue. Interim order to continue.
Why? Appellate authority will pass the order.
The appellate till the appeal is
all right. Till the appeal is decided, the interim order passed by this court.
Your Lordship, till the appeal is filed, Your Lordship.
Yeah. Provided you say till the appeal is decided, provided it is filed within the time indicated. The interim order passed by this court on
that is
24th December 2015 will continue. Right.
But I have to get certified copies of the order. That's why, because your Lordship may say if it is in court, then your Lordship may kindly direct the court to give them, because my learned friend says that
so it might have been, I say it might have been produced.
Might have been sent to the court.
You can obtain certified copies. You apply for certified copies and can get it.
No, I cannot.
Yes, assessment order. No. I want copies of the documents which have been seized.
No,
So-
you'll say on inspection, it will be
Yes.
open to the petitioner to see copies of documents forming part of the record,
Yes, ma'am.
which will be provided to him on payment of usual charges. All right.
Obliged.
Weekly list.
My lord, weekly list is some covered matter, my lord. Yesterday I mentioned it. Item number
He
49.
mentioned in the hour where that is not meant for mentioning. So I was not present. Anyway.
Item number 49, 5 cases is
49.
there. And the 77, 82 and 153.
My lord,
All are the ASO's order, my lord, after publication of draft R1.
All right. Did you see
49.
in view of the order passed by this court on 2nd January 2023 in writ petition civil 1608 of 2014 bracket Narottam Rath was State of Orissa. The impugned order of the ASO is set aside and the following directions are issued. Take from 3 and 4 here. The petition is disposed of. Same order in, give the item numbers again.
49, 77, 82 and 153. 153.
I have some cases, my lord. 109, 110.
Yes.
109, 110. In these cases, my lord, obedience order was passed by this honorable court and ASO passed the order.
So same orders.
Same order.
109, 110 also.
109, 110, 111, 12, 13, 14.
Up to 14, 114.
109 to 114.
Right. Okay. Sir.
Weekly list, item number 1.
May I please your lordship? I mean, I may be pardoned.
No problem.
Well, in this case, the repetition challenges the order, ex parte award passed by the industrial tribe. There are 4 grounds I have taken. Let's say here, on the term of reference was whether the management terminated the services of the workers. And in the award itself, after the notice, the management filed the written statement. Well, in that 3 stands were taken. The petitioner, the leverers working with this particular concern.
No, we had summoned the record. 1 minute. We had summoned the record. What happened? In 2 ID cases.
Yes, my lord. 61, 62 is supposed to. That is the last order, my lord.
That's right. Has the record come?
I was informed the record has come.
Where is it? So we are seeing it only for service of notice, sir.
Your lordship wanted the order sheet probably.
For determining the core question whether you've been served or not.
Right. So,
the record.
It's my copy.
What?
The order sheet.
Which order sheet?
What he says it is.
Give it back.
The lordship, the honorable court called for the LCR of both the records, 61 and 62.
Correct.
So that was ordered by my lord Justice Talpatra and Justice Sahu. And in fact, it was after the direction the records have come. So I have not the opportunity to look into that. I don't know whether the record is placed before my lord.
It is.
It is.
If you want to examine it, you examine it, sir. The records of both the IT cases are available in the registry. It will be open to Mr. Manas Mahapatra, Learned Senior Counsel appearing for the petitioner to inspect the record and make submissions on the next date. The inspection will take place in the chamber of the Registrar Judicial and in the presence of the Registrar Judicial. All right. List on.
List.
1st May. Interim order to continue. Right.
Obliged.
Item number 2.
Item number 2, though, is a settlement matter, but it is little different. That's the reason I made a mention to take it up before your lordship. It was a leasehold property. We are the purchasers of the leasehold property. Under the Survey Settlement Act, if your lordship can see the act, 36 proceeding and proceedings under chapter 2 and 3 are distinctly different. I mean, separate. If a lordship sees chapter 2 and 3 of the Survey Settlement Act, that deals with survey, preparation of record of right, fixation of rate, publication of the ROR and fixation of rate. Survey in if a lordship sees the act, it's a completely a scheme of itself, my lord. Chapter 2 regarding survey means there will be notification for survey. That's a self-contained chapter. In terms of that provision, there will be a survey by the Amin, villages will be surveyed, there will be appeal provision, revision provision under that chapter is there. Then it goes to the, after a survey, then it goes to the preparation of ROR, publication of the same, that is chapter 3, section 12 onwards. RORs are published, presumptive value of correctness on section 13, then that part is over, then fixation of rent. 3 stages of the settlement operation. Now, these 3 stages of settlement operation within the framework of Survey Settlement Act, again under 36, there is a provision for simultaneous proceeding. Simultaneous proceeding.
Simultaneous proceeding.
Right. Means all these stage 1, stage 2, stage 3 is given a go by. Under that, if that notification section 36 is published, the operation has to go on simultaneously. All survey, preparation of ROR, publication of ROR, fixation of rent will go simultaneously. Here in this case, the notifications initially during 74-75 were published independently, means survey notification, ROR notification, all those things were being done. Now, the draft ROR was already published in our name, that I have annexed, my lord. But at this stage, government during 97 abandoned this all stage-wise proceeding, my lord. Notified 36, means simultaneous proceeding will go on. Am I clear, my lord? Now, after this 36 notification was published, GA department files an appeal before the settlement officer on section 22, saying that the draft ROR in my favor is wrong, recorded in the government. Now, they do not give me a notice. They pass an order against me, directing recording of the property in the government khata. I have purchased it. My sale deed is there. My draft ROR is there. So, at best, this can be remanded back for a fresh consideration before the settlement authority.
Yes, Mr. Mohanty.
Is the only ground which he has raised that he was not heard by the, but this annexure 5. But it seems that notice.
They are all to the earlier owners.
Oh, yeah, he is the purchaser.
Yes, yes.
He is the
purchaser. There are judgments in that regard. Also, Mr. Mohanty knows it.
Pradeep Kumar Mishra is the person to whom notice was sent.
Right. I am the purchaser.
And he is the Dilip Tripathi, that is.
All right. You say the short ground on which the petition challenges an order dated 28th December 2006 passed by the settlement officer in appeal case number 397 of 2004 filed by the state against the vendor of the present petitioner, that is Sri Pradeep Kumar Mishra, was that Pravas Kumar or Pradeep
and others, let's you can say others.
And others, is that no notice was issued to the present petitioner, that is the subsequent purchaser, before the order was passed, directing entry of the name of the government of Orissa in the record of rights, (ROR) pertaining to the land in question. Paragraph. While directing notice to issue in the present petition on you say that the take off by an order dated 6th February 2015, certain applications filed for amending the writ petition were allowed. Stop.
The vendor, I mean, my owner was implicated as a party.
Yeah, impleading inter alia, Sri Pravas Kumar Mishra, bracket, the vendor of the petitioner, bracket, as an opposite party in the writ petition. Paragraph. A perusal of the input order reveals that the present petitioner was not made a party to the said appeal. Therefore, there was no occasion for notice to be issued to the present petitioner before the order was passed. Paragraph. On that short ground, the input order dated 28/12/2006 is set aside, and Appeal number 397 of 2004 is restored to the file of the settlement officer, before whom it will be listed for directions on 1st March 2023. So on that date, the petitioner will appear along with the downloaded copy of the order. Paragraph, the settlement officer will now proceed afresh and decide appeal case number 397 of 2004 after hearing all the parties, all the necessary and proper parties, including the petitioner, and dispose of the said appeal by reasoned order within a period of 4 months thereafter. Till such time, status quo as of today shall be maintained with the parties. The petition is disposed of in the above terms.
Item number 3.
My lords, item number 3, Lordship may kindly permit me to withdraw to file a better.
The memo is taken on record. The petition is permitted to be withdrawn with liberty to file a better petition according to law.
I'm obliged, my lords.
Item number 4.
With leave of your lordship, may I humbly submit my lords. I'm a bona fide purchaser for a piece of land right from the recorded tenant, and the record of right was issued in favor of the tenant on by Annexure 1, page 17, my lords. Then the sale deed is Annexure 2, and I was paying rent thereof. Also, I am in possession. But subsequently, page 36, I will take your lordship, that is Annexure 3. The record of right suggests that the land which has been purchased by me has been recorded in the government khata by 2 orders. One order is passed by the sub-collector Dhenkanal, and another one is Tahsildar Dhenkanal, dated 28th of December, and one is 13th of January 2011. One is 2010 and 2011. When I apply for the orders by Annexure 4, my lords, page 37 to your lordship's brief and relevant page 38, they say there are no such orders. The authorities, they give me an information that these orders dated 28 December 2010 and 13 January 2011, taking my property into the government's khata, these orders are not available in the lease case. So my mutation proceeding is pending before the authority and nothing is being done. My page paragraph 6 I have quoted, my mutation case number 2810-2010 in the files of the opposite part number 4 is still pending.
No reply filed, Mr. Mohanty.
Reply is
7 years now.
But so far as these orders are concerned, by virtue of which the ROR was published, Annexure 3, those orders are applicable. Now he is saying that
the orders are not available.
Available. That is what I
How will he
also
go to
say.
file an appeal if the order is not available? You file a reply despite 7 years having elapsed after notice was issued in the matter. No reply has been filed till
My
date.
lord, may kindly give one opportunity. I will search
Last
whether this,
opportunity to file a
these
reply on or
orders.
before 3rd April 2023. Return to be filed for the next date. Interim order to continue. List on 10th July.
My protection may kindly be extended.
Item number 5.
Grateful, by.
My lord, item number 5 may be taken after lunch.
All right.
Item number 6.
Item 6, my lord, on the last occasion, my lord had directed to produce the assessment order and the labels of the bottle, that whether the entry that will fall within mineral water or plain water.
Kinley water.
Yes, my lord. I have collected some documents.
Labels.
Yes, labels and literature from their website, my lord.
Appearing for the respondent.
More important label. What are the labels?
Label itself, it is written mineral, my lord.
Your lordships, I'm appearing for the respondent in this matter. Assessment order itself, the label description is captured. If your lordship will turn to page 16, assessment order. Your lordship, I believe, has 26 of 2017. Your lordship, the discussion starts at the bottom of the page, packaged drinking water, stroke mineral water. If your lordship will turn to page 17, I'll just read it, and does not fulfill the essential conditions to be classified as mineral water. In this context, the dealer who filed the wrapper pasted on the bottle of Kinley which reads as follows. Packaged drinking water, ingredients, treated water, minerals, sodium chloride, magnesium, sulfur, manufactured by Himjal Beverages Private Limited so and so, for and on behalf of Hindustan Coca-Cola Beverages Limited so and so. So your lordship, what we are selling is packaged drinking water. A label also contains the same. Now, because of the reverse osmosis process that undergoes in order to take out the pesticides and other elements, there are certain minerals also which are naturally present in a water which gets removed. The Indian Bureau of Standards specifies that certain minerals have to be added mandatorily if we are selling it as a packaged drinking water. Your lordship, my learned colleague over here can hand over the then applicable Indian Bureau standards. Mr. Aditya, can you just hand over the Indian standard in 2004 to his lordships? Your lordship has the document?
Yes, please. Yes.
Your lordship will come to the 4th page of the Indian standard.
Yes.
Your lordship will come to the definitions. 3.1 is drinking water.
Yes.
Drinking water means water from any potable water source, including public drinking water supply system, which in colloquial terms, your lordship knows we call as any water from any source that comes. Then your lordship will read 3.2, which is packaged drinking water, which is the item which we are selling. And your lordship will kindly mark other than packaged natural mineral water. Your lordship will now see packaged drinking water means water derived from any source of potable water, which may be subjected to treatments such as decantation, filtration, combination of filtration, aeration, filtration with membrane filter, depth filter, cartridge filter, activated carbon filtration, demineralization, remineralization, reverse osmosis, or any other method, your lordship may kindly note, to meet the prescribed standard and packed. It may be disinfected to a level that will not lead to harmful contamination in the drinking water. It may be disinfected by means of chemical agents and or physical methods to reduce the number of microorganisms to a level that does not compromise food safety or suitability. It shall be filled in sealed containers of various compositions, forms, and capacities that is suitable for direct consumption without further treatment. In case remineralization is a part of the treatment process, the ingredients used shall conform to the requirements of the Prevention of Food Adulteration Act 1954 and the rules frame thereafter. So, lordship, if I am selling a packaged drinking water which comes from a potable source, I have to undertake various processes. During the process, I have to also ensure that it conforms to the standards under the PFA, which will require me to include certain minerals also into it, so that the taste is revived, it is safe for drinking, and I am not in non-compliance to the regulatory standards. Your lordship, subsequently also under the new regulation, under the FSI, the same standards have been kept. Your lordship, I can just show those also. If Mr. Aditya, if you can hand over the FSI document.
Yes.
Your lordship will come to 411 at the top. So, my apologies, your lordship, I should have done running page numbering. My apologies, 411, your lordship.
Yes.
Lordship will come to the bottom 2.10.8, packaged drinking water.
Yes.
Again, other than mineral water, means
Yes.
water derived from surface water or underground water or sea water, which is subjected to hereunder specified treatments, namely decantation, filtration, combination of filtration, aerations, filtration with membrane filter, depth filter, cartridge filter, activated carbon filtration, demineralization, remineralization, reverse osmosis, and packed after disinfecting the water to a level that shall not lead to any harmful contamination in the drinking water by means of chemical agents or physical methods to reduce the number of microorganisms to a level beyond scientifically accepted level for food safety or its suitability. Lordship will turn over. Then your Lordship, they say that if your Lordship will come to the para subsequent to the proviso, the related packaging and labeling requirements provided in regulation 2.1, 2.1.2, 2.2.1, and 2.445 of FASI regulations. So, your Lordship, I necessarily have to do it. I have to mineralize it. In fact, the definition of mineral water is also contained in this. If your Lordship will come to page 409, that's the third page from the start of the document, your Lordship. That has also been specified as to what is a mineral water. Mineral water, your Lordship has 409.
Yes, yes.
10.7 defines mineral water and its requirement. Mineral water includes all kinds of mineral water or natural mineral water by whatever name it is called and sold. Description and types of mineral water, your Lordship, then they categorize the number of mineral water. That is, one is a natural mineral water, which is contained in Roman 1. Second, your Lordship, is the naturally carbonated natural mineral water, Roman 2. Roman 3 is non-carbonated natural mineral water. Number 4, decarbonated natural mineral water. Number 5 is natural mineral water fortified with carbon dioxide from the source. And number 6, your Lordship, over the page, is carbonated natural mineral water. In fact, your Lordship, if your Lordship will come to of page number 410, the third paragraph after 2, the transport of natural, your Lordship has the third paragraph in 400.
In bulk containers.
Bulk containers, your Lordship. That's a restriction, which is not there for packaged drinking water. And when your Lordship knows that there are 3 kinds of water as such. One is a potable water, one is the packaged drinking water, third is mineral water. Mineral water costs a lot, your Lordship. It's almost 8 to 10 times the cost of a packaged drinking water, and we are selling it as such. The label also says it. Because of the requirement of the then Food Adulteration Act, we say that minerals are included, which is required under the Indian standards. So, your Lordship, both in common parlance as well as in terms of technical test, as laid down in Akbar Badruddin Jivani and acknowledged by Honorable Supreme Court in Connaught Plaza, if there is a particular scientific definition or technical definition which I have to mandatorily conform with, so your Lordship, while interpreting a statute in terms of classification, will have to look at those requirements also.
Yes, what do you say?
My lord, here, my lord, under the statute, mineral water has not been defined, my lord.
No, here in this one it has. Just look at this compilation.
Standards. Indian standards and
He has not.
No, you've not given him a copy.
No copy has been sought on that, man.
1 minute, there's a notification, sir. Health and Family Welfare notification under the FSA Act.
2011.
They're called the Food Safety and Standards Regulations 2011. And you'll also have to see the BIS standard. Has you given him a copy of the BIS standard?
But in the label itself, they are writing mineral, my lord. In the label itself.
Given in the BIS standard.
Given.
He says, as part of meeting the BIS standards, they're required to do what is called remineralization. That is, they have to add minerals.
Yes, my lord.
To make it meet the standard, BIS standard, he said that will not convert into mineral water, which is already defined in the regulations, 2011.
Yes, my lord. But in the label itself, they are writing mineral, my lord. In the
writing is one thing, sir. What it is, what is the product? Is it packaged drinking water or is it mineral water? Because he says in the market, people understand these two differently. When they want mineral water, they'll go and buy mineral water. They want packaged drinking water, they'll go buy packaged drinking water.
Yes, my lord.
And mineral water, according to them, is far more expensive than packaged drinking water.
But in the ingredients itself, there is sodium and magnesium.
See, even packaged drinking water will have these things.
But precisely that 1.1 mg.
You have to focus on the definition of mineral waters. And see and explain how this product will come within the definition, that definition. That is what you have to do. Have you studied this? I think you need to study it at some depth. You can't argue it straight away like this. Look at case law that deals with these two things, mineral water and packaged drinking water. You see, the court has been shown by Mr. Manish Panda, learned counsel appearing for the petitioner.
Malos for respondent.
Respondent. Copies of the relevant provisions of the Bureau of Indian Standards specification regarding packaged drinking water, bracket, other than packaged natural mineral water, bracket, as well as a copy of the food safety and standards, bracket, food product standards and food additives, bracket, regulations 2011, bracket 2011 regulations, which contain a specific definition of single quotes mineral water, bracket, when unquote, full stop. It is submitted by Mr. Panda that the respondent's product is only packaged drinking water and not natural mineral water in terms of the above definitions and specifications. Paragraph, copies of the above documents have been handed over to learned counsel for the department, who needs some time to examine them and make submissions. List on. February 7th.
Your lordships are keeping it on.
7th February.
Your lordship, one more submission that I had made. I'm sorry for your lordships interjecting. Is that even we are selling it as packaged drinking water in our label. So we are not.
It's all right. Today we will not pass the final judgment, sir.
Sir, indeed, your lord.
This is your label you have given. No, you have given.
Yes, ma'am. I am for the.
So, but where are they saying with minerals?
Yes.
But they're saying packaged drinking water.
Two things has been written, my lord.
No, all water will have minerals, sir.
Precisely that 1.1 mg, and that means it has been added to the water.
No, does it take it mineral water? All right.
Our name will be reflected in the cause list.
All right. The names of the counsel for the respondents will be reflected in the process.
Obliged. Item number 7.
7 also, my lord, has directed to produce the assessment record. Yes, my lord, I am honorable.
The other day, my lords have seen at page 81, a ground was taken before the tribunal that no notice was issued for audit. And the tribunal very conveniently didn't deal with it and dismissed my appeal. Page 81.
You want to see the record, right?
Well, regarding this, I am submitting 2 orders, one of the Apex Code and one of our own High Court, my lord. In the Apex Code order,
that has been
Subhas and Company. Subhas and Company, that at page 6, the Apex Court has called out that the view is clearly applicable to the fact at the case. The emerging principles are non-issue of notice or mistake in the issue of notice or defective notice or notice doesn't affect the jurisdiction of the assessing officer.
Is it in relation to audit visit?
Yes.
My lord, then my lord, assessment notice has been issued to him.
No. Is this judgment?
No.
In the context of audit visit. You can't just pull out any judgment.
Our High Court also decided that the audit is a administrative Administrative effort, my lord.
No. The whole assessment is an audit assessment, sir.
My lord.
First step of that audit assessment is audit visit.
My visit was made, my lord. He is challenging the notice, my lord. Visit was made. He produced the books of account.
No. It's a revision. I have revised my return, paid tax, rupees 2,24,000. Now you reject because you say that it is after the visit of giving the receipt of the audit visit notice. You reject it. That is at the assessment order. That is Annexer 5, page 66. That I have Annexer 5. My lords, be pleased to see at page 69.
The context in this order of this court is very different.
Yes.
There are circulars challenged.
My lord.
And the question was, is the audit officer performing a quasi-judicial function or administrative function?
Yes.
That's a very different context. The apprehension was once an audit officer gives the report, the assessing officer cannot go behind it. That was the apprehension. That is not the issue here at all.
Sometime then might be.
For what?
Assessment record. It was on the next week only. We have
I've been after 1 year also, they will not find it.
Not 1 year. Then you.
I'm sure. And
let it be stay on board next week, my lord.
Let it.
I have no problem.
Stay on board.
Item number 8.
My lord, 8 is covered by case of automobile in respect of central sales tax rules. 12.4A, my lord. Rules 12.4A of the CSTO rules, my lord. Similar provisions is there, my lord. I'm reading, my lord, where after a dealer is assessed, under sub-rule 1, 2, 3 for any period, the assessing authority on the basis of any information in his possession is of the opinion that whole or any part of the turnover of the dealer in respect of any period has escaped assessment or has been under-assessed or has been assessed at a lower rate than the rate at which it is assessable, or that the dealer has been allowed wrongly any deduction from his turnover or exemption under the Act, or has been wrongly allowed set off input tax rate in excess of the amount admissible under clause C of sub-rule 3 of rule 7 of
So
the
we have to add another question of law now. Because the question framed is something else.
My lord,
question framed is regarding no suppression of any turnover, no fraud established.
my lord. My lord, question is at C.
No,
Page
28th November order.
Page number 5, my lord.
28th November order, sir. Kindly see.
Your lordship may adjudicate the question number 3, my lord.
I know. I'm saying what is framed is something else. We have to reframe it.
My lord. Question number C, my lord. Your lordship may kindly consider question number C.
Right.
Whether on the facts and the circumstances of
No,
the
I know. This is not framed. We'll now frame it.
Yes, my
Your
lord.
lordship, this question is required to be framed, your lordship, and also required to be adjudicated, your lordship, because this section 12, this provision is not parametric to 43 and section 10, your lordship, so far as OVAT and OET. Because your lordship, on the last occasion, your lordship has considered that communication is required. Your lordship, each and every argument into those two statutes, your lordship has stated that communication is required. Even acknowledge, your lordship has not accepted acknowledgement. Here, your lordship has specific finding, in the statute is that communication is not required.
My lord, after a dealer is assessed, my lord, dealer has not been assessed. Communication is subsequent event. The dealer has not been assessed here. Communication is secondary. My lord, after a dealer is assessed, my lord, in this case, the dealer has not been assessed under sub-rule 1, 2, 3.
Where after a dealer is assessed, was he
Yes,
assessed?
Your Lordship.
Yes, my lord.
Your Lordship, after the dealer is assessed, that is not objected, Your Lordship. Only so far as that the said return shall be accepted. Your Lordship might have remembered the deemed acceptance.
No,
So
my lord, there is no amendment here, my lord. After 1/10/2015, there is no amendment here.
Exactly, I am submitting the same thing. Since there is no amendment, this statute is from that beginning, Your Lordship, that deemed acceptance is not here.
No,
So
my
it
lord,
is-
the beam assessment is not applicable here, my lord.
Both of you saying same thing, sir.
Sorry, my lord.
Your Lordship, here what happened, in that case, Your Lordship, in 43-39(2), as well as section 9, Your Lordship, so far as the VAT and Anti-Tax Act, Your Lordship, prior to that, Your Lordship, the return shall be accepted. Your Lordship might have remembered the language. The return shall be accepted and deemed acceptance as per 1/10/2015 deemed acceptance. So prior to that, shall be accepted. So Your Lordship has determined that shall be accepted means there is acceptance must be there.
Whatever may be position, you
Your
have to
Lordship.
now demonstrate
Your Lordship.
whether he has already been assessed under subsection 1
Your
or
Lordship.
subsection 2 or subsection 3.
Your Lordship.
That is sine qua non.
Your Lordship.
So you demonstrate.
Your Lordship, that part I will argue that part. That part I will show from the record. That part for the only difference here is that shall be accepted, Your Lordship, in those cases such determined that shall be accepted means acceptance must be there and it has to be communicated. Here, Your Lordship, my respectful submission is that shall be accepted as self-assessed without any further communication. So, Your Lordship, that means the intention of the legislature is very clear that if at all the return has been filed and there is no error apparent on the set of face of record, then those returns are self-assessed, accepted and self-assessed, Your Lordship. So that difference I may be permitted to demonstrate, Your Lordship.
First, read the relevant rule and tell us where you're getting all this.
Your Lordship. Your Lordship, the relevant rule is that...
No, let him argue. Let him argue. Sir. Let him argue.
Tax audit. That is Your Lordship, in the CST book 1, volume 1, 127.
Yes.
Orissa rule.
Correct.
12, Your Lordship.
Yes.
Your Lordship, after submission of declaration forms and certificate as prescribed in Rule 7A of this rule, the declaration form or certificate so furnished shall be scrutinized with reference to the returns to which the declaration forms or certificate relate in cases where such return statement and declaration form or certificate as the case may be are found to be in order and correctly and completely filed in. There is no arithmetical mistake apparent on the face of return or statement. Exemption, deduction, concession under the Act and the rules made thereunder claimed in the return are supported by the declaration form or certificates as the case may be furnished, and the declaration forms or certificate referred to subclause 3 above are furnished on or before the due date as prescribed in Rule 7A of these rules. The said returns shall be accepted as self-assessed without any further communication to the dealer filing such returns, and in that case, the date of submission of forms, declaration, certificate along with statement shall be reckoned as the date of self-assessment. So here, Your Lordship, this provision is different, quite different from that of the provision of section 43, section 39 to read with section 43, as well as section 9, read with section 10, Your Lordship, of the Orissa Anti-Tax Act and VAT Act. So, Your Lordship, for this reason, Your Lordship, when there is communication is not required and there is no error and that shall be accepted, Your Lordship, so that judgment is not applicable. So, if Your Lordship frame, Your Lordship may frame
You just have to see the record to see when he submitted.
Your Lordship.
All right. So you'll get the record then.
Your Lordship.
All right. Let it stay on board.
My lord.
All right.
Mr. Mishra's blitzkrieg is unstoppable. He's become blitzkrieg using tiger tank. It's unstoppable. I was outside. And when I heard this voice, I was something explosion as a.
All right. Item number 9.
None of this.
Item number 10.
My lord, for item number 10, my lord, I am due to my personal difficulty, I am in virtual mode, my lords.
All right.
My lord, the issue before my lord is that, my lords, the control panel, motor starter control panel, ATS control panel is an accessory to pump substrates falling on entry serial number 29 of part 2 of schedule book. That is the issue, your lordships. Neither of the authority below, your lordships, all of them held that this is a unspecified goods falling under part 3 of schedule B and subject to tax rate of 12.5%. But none of the authority, your lordship, observed that these goods are not being an accessory to the motor pumps, your lordships. Lordship, kindly glance to page 27, your lordships. 27, last question, observation 1, your lordship. That is a heavier objection, my lords. While examining the cell, my lord, able to find out, my lord?
Yes, yes.
Okay. While examining the sales invoices, it is revealed that the instant business unit has effected sales of purely electrical goods like 150 SP fully automatic ATS control panel, motor starter panel board, other control panel by paying 4% or 5% instead of 13.5%. So that is the observation by the authorities, your lordships. And as per the contents of the dealer before the assessing authority, your lordships, kindly have a glance to page 35, my lords. Page 35, my lords. It is the petition contents before the assessing authority, your lordships. In this regard, it is also explained previously that the dealer basically is a supplier of pump sets, accessory and spare parts thereof under agriculture sector as well as the PS sector, public health sector. So basing the uses of accessory on the spare parts in pumps sets has caused the dealer and collected tax accordingly. The tax rate of pump set as per rate chart schedule B of part 2 serial number 69, but that should be my lord 29, my lords. There are some electrical goods coming under spare and accessory computers, and rate of tax on these electrical goods was 4% to 13%. These are all are parts and accessory of computer. The spare parts and accessory are listed by the London audit team under observation are specifically used for pump sets. My lord, the next line, all accessory and spares of pump sets are, and without this pump set cannot run, my lords. The pump set cannot run, that is the submission of the authority, your lordships. My lord, coming the order of assessment passed by page 36, your lordships. Page 36, my lord. The observation of the London authority, your lordship. Last two lines, my lord. It is observed from the sales invoices issued by the dealer has effected purely electrical goods like 150 SP fully automatic ATS control panel, motor starter panel, and other control panel, etc., which are taxable at the rate of 13%.
These are all control panels. How are they pumps? They can't be pumps.
Accessory.
My submit is accessories, my lords.
No. Accessories means what kind of accessories is the question. Let's go to the original entry.
My lord, page 10, my lord. Page 10, my lord. Entry serial number 29, your lordships. May I read out, my lord?
Yes.
Centrifugal, monoblock and submersible pumps and pump sets for handling water.
Where are these panels and all coming, sir?
No, I am coming to that, my lord. Corporate electricals and otherwise, and parts and accessories thereof, your lordships.
Agistem generis. Agistem generis.
My lord.
These also should be pumps. It should perform the same function as monoblock centrifugal pumps.
My lord. So my submission, without this pump set, without this control panel and motor starter panel, I cannot run the motor.
No, that it might be. But what are these ATS panels is the question.
ATS panel is automatic static control panel, your lordships.
Those panels are not themselves pumps. They may be accessories.
Yes, sir. That is the accessory, and that is a fine entry and entry serial number
electrical
accessory, your lordships. Very well,
but they could be an accessory to anything.
My lord.
They happen to be accessory to pumps, but they can be an accessory to anything else also.
But the specification is different for the accessory for the other goods and the accessory for the motor pumps, your lordships.
The same ATS control panel or motor starter panel can be applicable to other electrical goods also. Not just to the monoblock pumps or centrifugal pumps.
My lords, even the terminology control panel, the specifications for this water pump accessories is quite different for the household control panel, your lordships.
Where is the evidence for that?
I have given a detail in my apartment, your lordship, in the pleading, I have given a details of what is the goods and incorporated, your lordships.
Either literature or some expert has to be filing an affidavit, sir.
Okay, I will take care of that one, my lords. This specification is quite different. I will take care, my lords. The specification of ATS control panel for general use and ATS control panel for the motor pumps is quite distinguishable. I have to ascertain and find out, my lords.
See, one of the questions that arise for consideration is whether, for the purposes of entry 29, entries at serial number 29, part 2, schedule B of the OVAT Act, the 150 HP fully automotive ATS control panel and motor starter panel pump and other control panels are exclusive to the centrifugal, monoblock and submersible pumps and pump sets, or can be used in relation to other electrical goods as well. Paragraph, counsel, the petitioner undertakes to file affidavits of experts who can explain the above question. Who can explain the above? Right.
I have to find the electrical engineers, my lords.
Right. The affidavits be filed within 4 weeks with an advance copy to counsel for the department. List in the regular list on 1st July. On 3rd July. 3rd July.
Deep oblige, my lords.
After lunch.
Yeah.
The assessment record has been called for. The assessment unit is at Jaipur, your lordship, more than 500 kilometers. Your lordship, some time required to that CST matter, your lordship.
All right. So when do you want to?
Lordship, 2 weeks, 3 weeks time, maybe not.
All right, list in the regular list. On.
May pardon me, Lord.
1 minute, sir. March.
Gratefully, your lordship. Oh, blessed.
Items 3 and 94. Both are covered matter of your lordship that AS order that has been already decided.
73 and
94.
All right. Same order.
94.
Similar. Item number 91 also similar, my lord. That AS order is on requisitions.
All right. 91 also.
91.
Okay.
Obliged.
All right.
Weekly list item 11.
11, my lord, and 13, I'm sorry, my lord, has to go before some other bench.
Oh, I see. List before a bench of Justice Raman is not a member.
My lord was appearing before the tribunal of women.
Okay. All right.
11 and 13, my lords.
All right. On 13th March.
13th March.
Item number 12.
May I please, my lords. The questions of law, my lord, is been already framed by your lordships, my lord. And that is at page 12, my lords, of your lordship's brief, my lords.
Right.
First question, my lord, is whether on the facts and in the circumstances of the
sales
case,
suppression.
sales suppression.
That's covered.
My lords. And second one is, sorry. And second one is whether on the facts and the circumstances of the case.
Yes, admitted to that there is suppression.
Lordship, I'll just place the second appeal order, my lords.
Right.
I'll just take your lordship to page 28, my lords, the conclusion of the tribunal.
Right.
Paragraph 6. Lordship got it?
Yes.
Peruse the orders of both the learned forums below and the other materials on record. From the materials on record, it is seen that during audit visit, the visiting officials found out a number of purchase bills which were not being accounted for in the books of accounts, and the sale of those goods relating to those purchase bills were also not being accounted for in the sale register. During assessment, when the allegations of the AVR were confronted to the authorized representative of the appellant dealer, he failed to offer any explanation, rather admitted the discrepancies pointed out by the visiting official. Thus, basing on the allegations of the AVR and basing upon the admission of the appellant dealer, with regard to the discrepancies, the learned assessing officer examined the entire materials in details and determined the purchase suppression, Your Lordship may kindly mark it, to be rupees 25,30,476.67 and added a profit margin of 10% amounting to rupees so and so to it and determined the GTO accordingly. So my humble contention, my lord, is Your Lordships have held already in Prasad the jewelry, my lord's case, that which was almost similar, my lord. Where here, my lords,
No, but just come to page 20. The tabular column. In the remarks column, all of this is admitted.
All of this is admitted, my lords. So far as the purchase
Once the value is admitted, then he's only adding 10% as a profit margin. It's not that it's without basis.
Now, here, my lord, the purchase bills were concerned. We have said that, my lord, yes, there were purchase bills, and those purchase bills were not taken over to the sale register, my lord. So purchase bills, Your Lordship have already held, my lord, that purchases may be there, but with the absence of any proof of sale, my lord, there can't be any suppression. And what he has done, my lord, he has added 10% profit margin to the purchases.
Yeah. The different matters altogether.
So I was relying on Your Lordship judgment in Prasad.
No, but there the facts were not.
Yes, but there the facts was there was a shortage of gold, my lord.
No, there was no admission there. So there was no basis then for coming to those conclusions.
No, there was an admission in my very humble submission that yes, those purchases were there. The purchase bills were not taken.
Yes.
The purchase bills were not taken over to the sales account. No. Beyond that, no, there was no suppression. There was no admission. Your Lordship would appreciate. I'll just place that paragraph just before the table, my lords. From the above discussion and analysis, it is seen that the AVR has found some unaccounted purchases. The wave bills out of it, in utilization statement are duly examined with reference to the revised returns and statements. In AVR, it is examined that with original returns, wherein huge differences have been reported. Besides, the purchases and sale figures in the balance sheet for the years under assessment are more than the disclosed figure, as the balance sheet covers the transactions of Kolkata and Guwahati branch. The purchase suppression established or summarized below.
So established, the word established also.
Established not so far as this Kolkata and Guwahati branch is concerned. Not. Then he says the purchase suppression established are summarized below. And then he says that there are discrepancies in these three occasions, my lord. And I have said, yes, I have admitted that there are purchases.
Yes. Not. You say, while admitting this revision petition by the SSC, arising from an order dated 23rd September 2017 of the Odisha Sales Tax Tribunal, Cuttack Tribunal, dismissing the SSC's essay number 34 V of 2016-17. This court by an order dated 12th March 2018 framed the following questions for consideration. He produced the three questions. As far as the first question is concerned, the background facts are that on the basis of an audit visit report, the assessing officer completed the assessment against the petitioner under section 42 of the OVAT Act for the tax period April 12 to March 2014, after finding that there was suppression of purchases Full stop. In the assessment order, in a tabular form, the AO noted the particulars of suppression, the value involved, and importantly, in a remarks column, noted that the authorized representative of the SSC had admitted to each of the entries. Full stop. Paragraph. The above order was confirmed by the first appellate authority by the order dated 21st April 2016. Full stop. Thereafter, the SSC went before the tribunal, which has concurred with the finding of the AO as well as the first appellate authority. Paragraph. Relying on the judgment, the order dated 25th April 2022 of this court in STREV 347 of 2008, bracket Messrs. Prasad Jewelry was the state of Orissa, bracket Mr. R.P. Karnad, counsel appearing for the petitioner, urged that in the present case, there was no basis for the AO to have determined purchase suppression to the above extent without actually examining the materials in some detail. So, in other words, it was sought to be contended that the sale suppression figure was based on surmises and conjectures. Full stop. Paragraph. Unlike the case of Messrs. Prasad Jewelry, bracket Supra, in the present case, there appears to be an admission by the SSC of the figures of purchase suppression as set out in the assessment order. Full stop. Consequently, the order in Prasad Jewelry Supra is of no assistance to the petitioner. Full stop. As far as the present case is concerned, after noting the figures of purchase suppression, that were admitted by the petitioner, SSC, the AO determined a 10% profit margin as being reasonable in the facts and circumstances of the case to arrive at the final demand raised in the assessment order under Section 42 of the OAT Act. Having considered the orders under review and the documents placed on record, the court is not able to agree with the contention of the petitioner that the above determination is based purely on conjectures and surmises. Full stop. Consequently, question number 1 is answered in favor of the department and against the SSC. Paragraph. As far as questions 2 and 3 are concerned, since the penalty under Section 42 bracket 5 of the OAT Act is automatic, this court is not inclined to interfere even on that issue. Consequently, questions 2 and 3 are also answered against the SSC and in favor of the department. The revision petition is dismissed.
But I just add a word note. A 10% profit margin which has been added, let me just consider that. Okay, as your lordship pleases.
All right.
Obliged.
Okay.
Item number 14.
Sorry. No, what about 13 is over? Not correct.
Item number 14.
May it please, Milords.
Yes, please.
Milords will have your lordship's order of 27 July, where the question of law has been framed, whether the deemed dividend paid by the Orissa Stevedores Limited should be taxed in the hands of Mr. Mohimananda Mishra, the individual director who holds shares therein, or in the hands of the appellant firm of which he is a partner. So, Milords, the facts are like this, Milords. There are two entities, Milords. One is a company, the other is a partnership firm. The company, Milords, gave unsecured loan to the partnership firm. This company and this partnership firm, they have one common partner or a shareholder, that is Mr. Mohimananda Mishra, the individual. So, Milords, the question that arises is that this unsecured loan that was given by the company to the firm, it is to be treated as a deemed dividend, that's all right. But, Milords, whether it should be taxed in the hands of the individual or in the hands of the firm, that is the question. Now, Milords, dividend is something that is to be taxed in the hands of the shareholder. That is a settled position of law. my lords, it is a covered issue, my lords, in Principal Commissioner of Income Tax versus Ennore Cargo, my lords. I'll just pass on this judgment, my lords, which is squarely applicable on the facts of this case. In order. My lords, will see para 2, Roman 3 and Roman 4, these questions. Whether the appellate tribunal is correct in holding that deemed dividend has to be assessed only in the hands of the shareholders for whose benefit the money was advanced. Whether the appellate tribunal is correct in deleting the addition made towards deemed dividend on the ground that the assessee is not a registered shareholder of Messrs. Indev Logistics, from whom advance was received by the assessee company for the benefit of the shareholders who are also the common shareholders. Now, my lords, will see the findings of the
This finding that the advance is received for the benefit of the registered shareholders, where do we get that? How do we deduce that? See, the advance is paid to the company. It's not paid to the shareholders.
Yes, my lords, here in my case, the unsecured loan is given by the company to the firm. In the company, I am 36.95% shareholder. In the firm, I am 55% partner.
Not I, Mr. Mishra.
Oh, sorry, my lords. Yes, Mr. I'm sorry, my lords.
Freudian slip.
Yes, I'm so sorry, my lords. Grateful for your lordship pointing out. Now, let's.
No. So when the advance is given, it's given to the company.
It's to the firm.
Or to the firm.
Yes.
Now just see this judgment which you've handed over.
Yes.
Para 10.
Yes, please.
As indicated above, there is no dispute that the assessee did receive capital advance from Indev Logistics. There is also no dispute that there are common shareholders between the assessee.
In this case, my lords.
Therefore, quite correctly, as noted by the tribunal, though the advance received by the assessee company may have been for the benefit of the aforementioned registered shareholders. This part, how do we know that it is for the benefit of the shareholders?
My lords, that is a finding, my lords, that is undisturbed, my lords. That is, in fact, I am not on quarrel with that finding. I am on the point, my lords, who should it be taxed in the hands of? Whether the registered shareholder?
No. If the advance was given for the benefit of the shareholders, then what you say is right.
That is what is the finding, and that is what I am saying, my lords. I don't have any quarrel against that finding.
No, where is the finding?
My lords, will see the assessment order. And your lordship, just to point out, while your lordships were at it, that Madras High Court judgment, the assessee that is referred, the word assessee is a company.
Yes. Here it's a firm.
Yes, my lords. Anyway, my lords, it's a juristic entity.
Correct.
Now, my lords, will see the assessment order at page 20. At 22, my lords. As per annexure to point number such and such of the audit report, it is certified that amount of loan deposit taken accepted during the year is 3.7 crores. It shows that the assessee, that is the firm, has received during the year unsecured loan amounting to 3.7 crores from Messrs. Orissa Stevedos Limited. Perusal of the IT return and details submitted by the AR of the assessee, it appears that the assessee firm has 4 partners, namely Sri Mahimananda Mishra, Chandan Mishra, Charchit Mishra, Chinmay Mishra, having 55% such and such shares respectively in the firm. Sri Mahimananda Mishra is also a director in the company, Messrs. OSL, withholding 36.95% of shares in the company. Now, lords, on verification of the audit account and audit report, it is observed that OSL has shown total income of rupees 32.09 crores for the assessment year 11-12. In the present situation, the company versus OSL has given unsecured loan of such and such to the firm of the same director with substantial interest.
No. So the thing is, it's a wrong analogy that you've drawn. See, here in this judgment, the beneficiary entity was a company, and the company has shareholders, right? Therefore, there it could be demonstrated perhaps that the benefit actually inures to the shareholders.
Yes, please.
Here, the beneficiary is a partnership firm.
Yes, my lords.
And there are partners. There are no shareholders.
Yes,
the question of there being a shareholder who's benefited by the advance doesn't arise at all here. It is the firm. It is the firm that's received the advance.
That's correct.
So in the firm's hands, it has to be a deemed dividend. In the firm's hands.
No, my lords.
It can't be in the individual partner's hands. Please.
Yes, my lords. May I just respond to that, my lords?
Yes.
My lords will see that here it is about dividend.
Yeah,
now, dividend.
Deemed dividend.
Yes, deemed dividend.
It's couched. You see, when you give an advance, how should it be treated is the question, right?
Yes, my lords.
Because they're all related entities. You're concealing what is actually an income by showing it as an advance.
My lords, for a moment, we'll see 222E, the provision.
Yes.
Which is I've extracted at page 5.
Right.
Any payment by a company, not being a company. So, my lords, what is required should be a payment by the company.
Not being a company in which public are substantially interested.
Yes, my lords. So it's
yes.
This is not a company where public
are substantial.
So any payment by a company. Yes. Company here is OSL, my lords.
Correct.
Of any sum.
Yes.
Whether as representing a part of the assets of the company or otherwise, made after such and such, by way of advance or loan to a shareholder. Being a person who is the beneficial owner of shares, not being shares entitled to a fixed rate of dividend, whether with or without a right to participate in profits, holding not less than 10% of the voting power or to any concern in which such shareholder is a member or a partner and in which he has substantial interest, or any payment by any such company on behalf or for the individual benefit of any such shareholder, to the extent to which the company in the case possesses or accumulated profits. My humble submission, my lords, here is that it can be a dividend only in the hands of a shareholder. And a shareholder is the one who is reaping benefit from a company. And therefore, the deeming fiction comes in where it is treated as a deemed dividend. Now, here in the present case, my lords, the person, individual, that is Mr. Mahima Mishra, has substantial interest in a concern which has received the unsecured loan from the company. And therefore, my lords, my humble submission is, since it is given to an entity where the shareholder is a beneficiary because of 55% partnership.
No. What is the shareholding in OSL?
36.95%.
Of which entity?
Of OSL, my lords.
No. OSL's shares are held by whom? By the firm?
No, my lords. That's the point. It has been, my lords, what happened? The confusion happened because of the naming. One is Mr. Mahimananda Mishra.
So it's only Mr. Mishra who holds shares.
It is Mr. Mishra who holds shares, not the firm. And that is, in fact, that is where the confusion started. And therefore, my humble submission is that...
What did they do in Mr. Mishra's individual returns? They did not tax him for this.
No, my lords. They have not taxed him. And therefore,
so then you should offer it in his returns.
That's
the point.
Milords will see the CIT.
You can't have it either way then.
Milords will see the CIT appeals order.
You should agree to then offer it as his income.
Milords will see the CIT appeals order. What the CIT appeal did, your lordship will find at page 28.
Even in your section 69 and all those cases.
Yes, Milords.
If the so-called shell company has actually filed a return in which it has disclosed the income, that's one of the reasons in exempting the person.
Yes, section
who's actual beneficiary.
In cash credit, section 68, share
69.
application. The only thing there is that there is an exception provided. There is a proviso which says that you can question the source of source.
Source, correct.
That's the exception.
Correct.
Or else you can't question the source of
but here,
we'll see, your lordship.
This Mr. Mishra has offered it for tax, then it's different.
29, your lordship will see.
Most probably did not offer it for tax.
Milords, that doesn't mean, Milords, I will be taxed, the firm. 29
devices. These are all devices. At the end of the day, they are devices.
29, Milords will see.
All right. Page 29.
Yes, Milords. Milords will see, this is the finding of the CIT appeal. Para 5. I find prudence with the submission of the appellant that since the appellant firm, Messrs. Mahimananda Mishra, is not a shareholder in the paying company OSL. The amount disbursed to the appellant from the said company should not be treated as deemed dividend in the hands of
So
the
the second part, but the same amount should be treated as
Yes,
dividend
my
in the hands of Mahimananda Mishra. What did they do after this?
Milord, that is for the department to answer, Milord. But Milord will see the department didn't.
No, para 6. In fact, he says the AO should take remedial measures.
Yes, Milord.
To maintain this.
Yes, I don't have. In fact, I never filed an appeal against this order.
The para 6 and terminal orders also say that the amount should be treated as deemed under 220T of the Act in the hands of Sri Mahimananda Mishra as described above.
Yes.
The AO is directed to take the remedial measure.
Correct. This is what he's also reading. You're agreeing to this.
And tribunal also say.
No, tribunal reverse this. That's why he's here.
The tribunal also say we remit the disputed issue to the file of the CIT appeal to verify the facts and decide the issue after providing opportunity of hearing.
The CIT has already found it. Why is the need to set it back then?
In fact, went on another tangent. It says, please verify if the shares of Messrs. Mahimananda Mishra has.
There is no share of
I'm sorry, Milord. If the shares of OSL has been purchased by this person by deriving income from Messrs. Mahimananda Mishra. Milord, OSL came in 1978. The firm came in 1986. How can the firm give money to the?
That's all right. You say the present appeal by the SSC is directed against the order dated 10th October 2017, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT-80. In ITA number 52/CTK/2016 for the assessment year, bracket AY 2011-12. Paragraph, while admitting the present appeal on 27 July 2022, the following question is framed to consideration. Paragraph, this court has heard the submissions of Mr. S.K. Acharya, learned counsel for the appellate, and Mr. Chimanka, learned senior standing counsel for the department. Paragraph. The facts relevant for the present appeal, as set out in the assessment order, is that the SSC is a firm engaged in the business of labor contract under the name and style of Messrs. Mahimananda Mishra. Full stop. Admittedly, the said firm has 4 partners, one of whom is Mr. Mahimananda Mishra, having contributed 20% of the shares of the firm. Full stop. There are 3 other partners as well. Paragraph. Mr. Mishra also happens to be the director of Orissa Steel Mills Limited, bracket OSL. And in that company, that is OSL, he holds 36.95% shares. Paragraph. During the AY in question, OSL gave an unsecured loan of rupees 375,78,685 to the firm, that is Messrs. Mahimananda Mishra. Full stop. Of this, rupees 174,04,185 was received as cash. Full stop. The AO proceeded to treat the above unsecured loan as a deemed dividend in the hands of the firm and added it to the income of the firm, invoking section 2 bracket 22 bracket small e of the Income Tax Act 1961 bracket Act. Paragraph. When the SSC took the matter in appeal to the Commissioner of Income Tax Appeals bracket CIT-A bracket, it was noted by the CIT bracket A in the order dated 16th November 2015, allowing the appeal, that in terms of section 2 bracket 22 bracket E, the amount could be treated as deemed dividend only in hands of the shareholder, since he is the beneficial owner of the shares in OSL. Full stop. Section 2 bracket 22 bracket E reads as under, take from page 30, the italicized portion. Full stop. The plain reading of the above provision indicates that the taxing of the deemed dividend has to be in the hands of the shareholder of OSL. Stop. In the present case, admittedly, it is Mr. Mishra in his individual capacity who holds 39.5% of the paid-up share capital of OSL. Full stop. On the other hand, Messrs. Mahiman and Mishra, the firm, does not hold any shares in OSL. Full stop. Consequently, this court finds that the CITA was right in its conclusion in para 6, which reads as under. Reproduce para 6 paragraph. The ITET in the impugned order has, in the considered view of this court, needlessly remitted the matter to the CITA on the ground that it was not clear whether the deemed dividend should be taxed in the hands of the SSC's partner or in the hands of the SSC. Full stop. Since the plain reading of section 2(22)(e) of the Act makes it clear that the deemed dividend is to be taxed in the hands of the individual shareholder and not an entity which does not hold shares in OSL, the question of remanding the matter to the CIT(A) did not arise. Paragraph. For the aforementioned reasons, the question framed by this court is answered in favor of the SSC and against the department. By holding that the deemed dividend should be taxed in the hands of Mr. Mahiman and Mishra, the individual director of OSL, and not in the hands of the appellant SSC firm. Paragraph. The court reaffirms the conclusion reached in para 6 of the order of the CIT(A). Full stop. The appeal is accordingly disposed of, while setting aside the impugned order of the ITET.
Great. My lord, item number 5 is Passover. I am ready. My brother wants time.
I see.
Let it be board tomorrow.
All right, it will stay on board so that.
Item number 15.
My lord, question of law was admitted by this honorable court was whether the tribunal is justified in holding that the ITC was liable to be reversed as per section 29 small b oblique 29 small I Roman of the OVAT Act in respect of replacement of the damaged stock. Undisputedly, when some stocks received against a tax invoice were replaced by the selling dealer due to damage in transit, for which no revised tax invoice nor credit notes were issued, nor any adjustment in the sale price was made by the selling dealer, thereby no reversal of ITC was called for. First appeal was allowed by the first appeal was allowed. Tribunal reversed the first appellate order without considering annexure 2 and 3, my lord. Without considering, you take your lordship may kindly see the tribunal order. Page 7, my lord. First paragraph. On perusal of the order of the learned DCST.
1 minute, I think this is. I think he can't be part of this.
My lord.
Look at the appearance before the tribunal, sir.
Mr. Justice Raman has appeared.
I have not seen, my lord.
Let's be for a bench of which Justice Raman is not a member.
Sorry, my lord. I cannot
call later. On 13 March.
Pardon.
Item number 16.
Item 16, my lordship, by virtue of this corporate insolvency resolution plan, the demand in question covers the matter, my lordship. My lordship have already passed similar orders in this petition. My lordship, if in other matters there additional affidavit was been filed, my lordship, if permit, or my lordship may pass.
All right. It's not in dispute that the petitioner has gone before the National Company Law Tribunal in proceedings under the Insolvency and Bankruptcy Code and that a corporate insolvency resolution process bracket CIRP was initiated against the petitioner SSC. Full stop. The dues of the petitioner are apparently covered by the insolvency resolution plan that has been affirmed by the NCLT and approved by the NCLAT. Paragraph. Following the decision of this court dated 21st June 2011 in Writ Petition Civil 8259 of 2019 bracket Sri Metallics Limited with State of Orissa, the impugned demand, the impugned assessment order dated
Here the question only penalty.
okay, the impugned order imposing penalty.
My lords.
All right. The penalty under section 10 capital B read with section 10 capital A of the CST Act is set aside. Yeah, consequently, the impugned order of the tribunal and the corresponding orders of the first appellate authority and the assessing authority are set aside. On this aspect are set aside. The revision petition is disposed.
Yes. Item number 17.
May it please your lordships.
Yes.
My lords, an assessment was reopened under section 43 of the Orissa Value Added Tax Act and notice under Annexure 1 in Form 307 was issued. Then, my lords, I asked for the reasons under Annexure 3 at page 21. Then reason was communicated under Annexure 4. Under Annexure 4 and 4A, I asked for the reason was communicated on Annexure 3 at page 21. Then I asked for the
fraud report.
That
was not given.
Yes. And an order of assessment was passed under section 43, Annexure 5 at page 24. Lordship will kindly see page 28. The imposition of penalty. I am only on the imposition of penalty under section 43 bracketed 2.
After NALCO,
two questions have been framed, sir.
Yes.
On
Lordship will kindly see
2018,
this.
penalty was one question, but even the non-supply fraud report.
Yes.
That is also formed a
Yes.
separate question.
Malice. And the tribunal, Lordship will be pleased to see that tribunal, the order is at
45.
page 45 to 51. The learned tribunal, Lordship may kindly see para 8, then para 9. I'm just placing para 9 in case in hand.
Yes.
The learned STO has imposed penalty upon the application appellant dealer under section 43 bracketed 2 of the Overt Act as if this is an automatic one. He has not assigned any reason under what basis he satisfied himself to arrive at a conclusion that the escape assessment has been caused due to the fault of the appellant dealer and the same is without any reasonable cause. Even the learned JCST has also not considered this aspect and has confirmed the order of the learned STO in this regard in a mechanical manner. The principle is very much clear that the subjective satisfaction of an authority to arrive at a conclusion should be based on an objective facts. Therefore, while imposing penalty under section 43 bracketed 2 of the Overt Act, which is totally a discretionary one, the assessing authority must consider all the relevant facts and also the reasons assigned by the dealer for its failure to comply the statutory provisions. Now, Lordship may kindly see, having observed this, the learned tribunal comes at proceeds in para 11. As noted above, it is true that the learned forums below have not considered the relevant factors and the settled legal principles before imposition of penalty upon the appellant, dealer. Sorry.
Satisfaction has to be of the assessing authority, not the tribunal.
Yes, my lord.
So the tribunal then takes on the role of the assessing authority and says, let me be satisfied.
Yes. And my lords, the satisfaction, my lords, the judicial discretion, which is the discretion conferred upon the assessing officer, has to be used judicially. My lords may remember the case of Commissioner of Police Govindas Bhanji, my lords, 51 Supreme Court, para 17. That is very, there the Supreme Court said that it's not that you come and just write something. So, my lords, 43(2) gives a discretion.
So only on penalty will interfere.
Yes.
Not on this.
Yes.
All right.
No satisfaction has been recorded by the assessing authority.
The present revision petition by the SSC arises out of an order dated 19 January 2018 of the Orissa Sales Tax Tribunal, Cuttack, in essay number 308(B) of 2014-15, filed by the SSC. Paragraph. While admitting the present revision petition on 2nd July 2018, the following questions were framed for consideration. Paragraph. On question number A, the court finds that the tribunal in the impugned order has in fact agreed with the SSC that the assessing officer failed to record reasons before issuing a show cause notice in terms of section 43(2) of the OVAT Act for imposing penalty. Full stop. In fact, tribunal observes, open quotation, the principle is very much clear that, the subjective satisfaction of an authority to arrive at a conclusion should be based on objective facts. Full stop. Unquote. The tribunal has further observed, open quotation, it is true that, the learned forms below have not considered the relevant factors and the settled legal principle before imposition of the penalty on the appellant dealer under section 43(2) of the OVAT Act. Full stop, unquote. Paragraph. However, without stopping at the above conclusion, the tribunal appears to have taken upon itself the task of recording a subjective satisfaction for the purposes of section 43(2) of the OVAT Act. Full stop. This, in the considered view of the court, was impermissible for the tribunal to do. Full stop. Once it was clear that the mandatory requirement of section 43(2) of the OVAT Act was not complied with by the assessing officer, then the penalty imposed by virtue thereof had to go. Paragraph. Consequently, as far as question A is concerned, it is answered in the negative, that is in favor of the SSC and against the department. Paragraph. However, as far as question B is concerned,
I am not pressing it.
Since it is not pressed by the petitioner, at this stage, the court does not consider it necessary to answer the said question. Paragraph. To the above extent of imposition of penalty, the impugned order of the tribunal and the corresponding orders of the CIT of the first appellate authority and the assessing officer are hereby set aside. The revision petition is disposed of.
Allowed, my lord. Revision.
Disposed of. No. One question is not pressed.
Question is sorry. What I pay, my lords, lordship may make it
reportable. All right. All right.
Item number 18.
May I please your lordship? In this case, the dispute before your lordship, that before amendment of coming into force of the mining service, the transportation done by the contractor inside the mining premises, whether it will come under the goods transport agency or not. The similar, if your lordship will come to the impugned order.
My lord, may I submit your lordship?
Let me complete, Mr.
My lord, just one line, my lord. It is below monetary limit. Tax demand is 73 lakh.
No, my lord. If your
limit is 1 crore.
If your lordship will add tax and penalty, it will cover around 1.5 crore.
No, my lord. The basis is tax. Basis of qualification is tax.
No, the disputed demand, my lord.
No, tax amount. Not disputed demand. It is tax.
Just see the notification. You have the monetary limit notification. Does it say the disputed amount of tax or penalty?
It's a disputed demand.
No, let's read it.
Okay. वाटर लिमिट ला तो वाटर लिमिट कर लो ये लेके डबल 270 T27
Mr. Kurmi, it simply says monetary limit.
No, my lord, I will share circular, my lord. Circular says it is a tax amount, not the penalty amount. I'm just saying circular, my lord.
No, it has been modified. There is an earlier notification that has to be seen whether it is a tax amount or the demand amount.
No, the earlier one I will show you, lordship.
All right.
Earlier the amount, tax limit was 50 lakhs. That is now increased to 1 crore. Only the limit is by this notification of circular. Only the amount is modified. But the rest of the conditions remains the same.
Where is that circular? Where is that circular, sir?
My lord, I'm just sharing your lordship. And my lord, so also the dispute relates to classification. And so far as the question of classification is concerned, it has got a direct and proximate relationship with the rate of duty. And that being so, the appeal would lie to Supreme Court on 35L and not on 35G.
Anyway, that's the second argument. If this below monetary limit, we need not go into that. Tax or
Sivom file now, Sivom file, Sivom first file.
it does not say which tax or penalty or what. It only uses the word monetary limit.
My lord, I have circular dated 17th August 2011, para 2. I am reading, my lord, if your lordship permits. For ascertaining whether the matter would be covered within or without the aforementioned limit, the administrative element, the determinative element would be the duty tax under dispute.
Oh, I see.
It is that, my lord. My lord, I will share, my lord, in a moment, my lord, I will share with your lordship. Para 2 of circular number 390, which is referred in this. In para 4, it is referred, my lord. It is circular number 390 oblique miscellaneous MISC oblique 163 2010 JC 82011 dated 17 August 2011, my lord. Para 2 reads, for ascertaining whether a matter would be covered within or without the aforementioned limit, the determinative element would be duty oblique tax under dispute.
Your lordship, kindly come to clause 4 of the circular dated 2019 million. It may be noted that issues involving substantial question of law as described in para 1.3 of the instruction dated to 2011 would be contested irrespective of the prescribed monetary limit.
Yeah, for that, it must be substantial question of law.
My lord, what has happened, my lord? In this case, if your lordship will see, in this case, in a similar case, what has happened? There are different views are taken by the learned sister, and the matters went to the Honorable Supreme Court. Supreme Court, while considering those cases, has directed the learned sister to constitute a larger bench to decide the same issue, which is right now before your lords. Till it is pending.
The larger bench is still pending.
Yes, ma'am. As per my instruction, it is still pending.
My friend is not correct.
That is signing my case.
My lord, may I throw some light, my lord? My lord, as per direction of Supreme Court, a larger bench was constituted. Larger bench matter was referred to larger bench, considering one High Court judgment and one tribunal judgment. There was a dichotomy between these two judgments. Matter went to the larger bench of tribunal. Tribunal said there is no difference between the two benches of the tribunal. One is High Court, one is tribunal. And then again we went to the Supreme Court, and before Supreme Court is mentioned that the reference should not have been made. Then Supreme Court recalled that order. So larger bench is no more there. Larger bench is no more there.
The point which is submitted by my lord and friend, that is with regard to some different issues, my lord. Not because for a GTA.
The entire order has been recalled, is this?
My lord, not for the GTA, the Goods Transport Agency, my lord.
My lord, only reference was with respect to cargo handling. My friends before your lordship only on cargo handling. GTA is not an issue at all. Kindly see the question of law.
Sorry, it is cargo handling. It is cargo handling.
My lord, kindly see the question of law. On cargo handling, there was a reference to larger bench. Now larger bench is no more there.
Right.
And classification issue, my lord, judgment of there are so many judgments of different High Court, Supreme Court also in Navin Chemical. My friend is there, my lord. On Karnataka High Court judgment may kindly be seen, in which all the judgments are compiled in one place. That is in small comparison, my lord. If your lordship would kindly see judgment of Karnataka High Court in the case of.
There is no dispute regarding classification.
Scott Wilson, my lord. Scott Wilson judgment. Last page, my kindly see, my lord. Last but one page. It has been principle has been summarized there. Scott Wilson judgment, last but one page. Got, my lord?
Yes.
Para 36, my lord. The bottom para. Broadly, my lord.
1 minute, sir. He's still handing over. 1 minute.
My lord. I'm sorry.
Judgment, sir. Karnataka High Court is this.
Scott Wilson.
No, it's not in this.
Scott Wilson.
Scott Wilson.
Scott Wilson.
My lord, kindly see last but 2 pages, my lord. Para 36, bottom. Got, my lord?
Yes.
Broadly, the following disputes, after analyzing so many judgments of the High Court, Supreme Court, this is the summary of the conclusions, your lordship. Broadly, the following disputes do not fall within the jurisdiction of High Court under section 35G of the Act. 35G of Central Excise Act is made applicable to service tax. A. Dispute relating to service tax payable on any service, taxable service. B. The value of the taxable service or purpose of assessment. A dispute as to the classification of services. Here the dispute relates to classification of service, my lord. Whether those services are covered by an exemption notification or not, whether the value of service for the purpose of assessment is required to be increased or decreased. The question
of whether here classification is either as cargo handling services or as what?
Mining service.
Mining service.
No, the tribunal has held it is a mining service My lord, the scope of work was excavation of iron ore, picking of iron ore, sizing of iron ore, transporting it to the screening plant, screening in the screening plant, then transporting it to the railhead, and then loading and sending by railways, your lordship. Now, in this entire composite contract, essentially for mining, loading was one of the elements. Loading of the excavated iron ore at the mine, taking it to the screening plant, from the screening plant, screened iron ore, taking it to the railhead. In these two elements, my lord, there's some loading is involved. Now the contract is essentially for mining. What the department now contending that in the contract, there is some element of loading is involved. So the entire contract will go into the category of cargo handling service. That is what the department is saying. What tribunal has held? Tribunal has held, my lord, applying the principles of classification under section 65A, that the contract is essentially a contract for mining. Therefore, the entire contract will go under the mining service. And on mining service, my lord, the levy has come from 1/6/2007. This period is prior to that. The period in this case is, my lord, prior to that. That is, your lordship, the period is, my lord, August 2002 to September 2004. Period is prior to that. Now, my lord, in the small compilation, my friend has handed over. The Bombay High Court in the case of Indian National Ship Owner has said, insertion of a new entry. My lord, the cargo handling came from 16/8/2002. Mining came from 1/6/2007. Now, the the Honorable Bombay High Court in the case of Indian National Ship Owner has held that when a new entry is inserted without altering any other entry, it would presuppose that prior to that entry, there was no levy on the services. That is in the, my lord, Indian National Ship Owners, which is upheld by Supreme Court. Lordship would kindly see the compilation, my lord. Small compilation I have handed over, Lordship.
Already handed over. Page 22 of the compilation.
My lord, kindly see the definition, my lord. Before I go to judgment, kindly see the definition.
Anyway, do we need to go into all that if it's below the monetary limit?
It is below monetary limit, my lord, also not maintainable before this honorable court.
Yes, what do you say?
My submission may be recorded because of the exceptional, yes.
Because of the
exception, my lord. Exception.
No, there is no that exception because they have recalled the order, Supreme Court. All right. You say the present appeal by the department arises from an order dated.
May I clear your lordship? Let me take instruction with regard to monetary limit.
No, sir, it's okay. Order dated 14 July 2017. Passed by the Customs Excise Service Tax Appellate Tribunal, Eastern Regional Bench, Kolkata, SISTAT. Disposing of the SSC's Service Tax Appeal number 133 of 2008. And thereby setting aside the order dated 30th March 2007, passed the Commissioner of Central Excise. Paragraph. The background facts are that the respondent SSC is a racing and transporting contractor engaged in carrying out mining activities like raising, shifting, loading and unloading and loading into railway wagons of iron ore at Kalta Iron Ore Mines, raw material division of the Steel Authority of India at Kalta, Sundargarh, Orissa. In terms of a work agreement entered into between the SSC and SAIL since August 2002. Paragraph. On the basis that the SSC was rendering single quotes cargo handling services, unquote, under clause 23 of section 65 of the Finance Act 1994, A show cause notice was issued on 3rd August 2004, seeking to raise demand of service tax on the basis that the SSC had been rendering single quotes cargo handling services. Unquote. Against the adjudication order of the Commissioner of Central Excise, dated 30th March 2007. An appeal was filed by the SSC before the CISTAT. Stop. The tribunal agreed with the SSC that the work carried out by the SSC is essentially one of mining, and therefore it is only with effect from 1st June 2007 a specific entry for tax on mining services was introduced in the Finance Act. Full stop. On that basis, it was held that the impugned demand was unsustainable in law and the adjudication order was set aside. Paragraph. One of the first questions, a preliminary objection has been raised by Mr. Kurmi, learned counsel appearing for the SSC, that the tax limit, monetary limit of the present appeal being below ₹1 crore, the present appeal is not maintainable. Paragraph. Mr. Satyajit Mishra, learned senior standing counsel for the department, on the other hand, submitted that if the penalty amount is included, then the monetary limit would be above ₹1 crore. Secondly, he submitted that in terms of para 4 of the instruction dated 22nd August 2019 of the Central Board of Indirect Taxes and Customs, bracket CBITC, bracket, since the appeal involves a substantial question of law, as described in para 1.3 of the earlier instruction dated 17th August 2011, the present appeal was maintainable. Stop. In support of his contention regarding substantial question of law, he referred to an order passed by the Supreme Court of India you have the Supreme Court order.
This is the High Court.
High Court order. He referred to an order dated 4th May 2016 of this court, referring the issue on classification of the services, that is whether as mining services or cargo handling service, to the larger bench of the CISTAT. Paragraph. Mr. Kurmi pointed out that the said order was subsequently recalled and therefore the matter was no longer before the larger bench of the CISTAT. Paragraph. It does appear to the court that with the SSC admittedly carrying out the cargo handling services for the purpose of the present appeal for a period prior to 1st June 2007, question of making the mining services undertaken by the SSC amenable to service tax did not arise. Full stop. In the considered view of the court, this is essentially the considered view of the court, the view taken by the CISTAT that the task performed by the SSC is essentially a mining service and not a cargo handling service, appears to be a plausible conclusion that is not called for interference. Full stop. Therefore, paragraph. Mr. Kurmi has also drawn attention to para 2 of the circular dated 17 August 2011, which clarifies that the expression single quotes monetary limit unquote would essentially refer to the excise duty involved and would not include the penalty or interest amount. Full stop. Since the basic duty involved of excise involved is below ₹1 crore, the appeal is certainly below the monetary limit. Paragraph. Whether the service carried out by the appellant is cargo handling service or mining service is essentially a classification dispute. Full stop. Consequently, following the judgment of the Karnataka High Court in Commission of ST Bangalore versus Scott Wilson Kirkpatrick India Private Limited 2011 23 STR 321 bracket Karnataka, the court holds that the appeal against the order of the stat would lie, if at all, only to the paragraph. For all of the aforementioned reasons, the court declines to entertain the present appeal, leaving it open to the department, if it so chooses, to avail the other remedy available to it in accordance to the appeal is disposed of.
Item 19.
May I please? I have received the objection copy tomorrow from my learned brothers and filed that reply. The reply to the complaint filed by the commissioner, my lord. All of the issue, my lord, whether I am the exporter or not, that is the whole question decided by this honorable court. In their objection, they have stated that I am not treated as exporter as because I have no import-export code. Paragraph 7 of their objection, man. In answer to this, I have obtained import-export code. I have already enclosed in my reply at page 41 the import-export code. That is, I have. The department said that as because I have not that code, so I am not treated as the exporter, not constituted as the exporter, man. In this instant case, the facts remains this, my lord, that I have no piece of land in Paradip Port Trust. That's why while I'm exporting the materials, so I utilize two persons having their land at Paradip Port Trust and dumping the whatever amounts we're going to export it there and there. From that spot, it has been exported, my lord. So for this export, there was an agreement with me, with foreign buyers. The department has not denied it. The foreign remittance is in my favor. Department not denied it. Department has to say that as because bill of landing and shipping bill, my name is not been reflected. That's why you are not exporter. You are not eligible to get refund. Whatever the amount already allowed by the commission appeal at paragraph 6 to 9, they have already dealt everything in my favor that I am eligible to get to treated as exporter and eligible to get the refund, my lord. And against that order, department has to go to the tribunal, and tribunal in a cryptic order has passed that whatever commission appeal has stated is not correct. Now I am before my lords, and the question has been raised and already been accepted by this honorable court.
By which order?
That is order dated.
Ah, 1, 2, and 3, para 26.
Man.
Whether the tribunal contribute to the right to claim a bill from the service tax. 26. So in the earlier year, your plea has been allowed. So one question is on doctrine of precedent.
My lord.
There's a decision of the coordinate bench
That we have already mentioned because that decision has been cited by the department in his written notice submission, which has not dealt by the tribunal itself. They are only interpreting the section 216 and 220 of the Indian Export Customs Act. By interpreting in misinterpreting way, they have stated that you are not the exporter. Because the contract is with me. I have signed the contract and I have supplied the materials. As because I have no land at Paradip, that's why I utilize somebody's land for export purposes. And bill of lading obviously expertly should be in the name of that person, those who are uploading the materials. And the department said that you are no locus standi to claim refund. Foreign remittance in my favor. I got the foreign remittance. They have not denied it. They only denied as because your name has not been reflected in bill of lading and bill of shipping. That's why you are not entitled. That's why you are not treated as exporter. That is only allegation against me. And another allegation is I have no Indian import and export code, but I have that. They have never asked me to produce that things. Neither in assessment adjudicating authority, nor appellate authority, nor tribunal, nowhere they have not questioned that I have that code or not. But I have that code. I have enclosed here.
No, on the first question, if the bill of lading is not in your name,
yes,
and you're not shown as the exporter in all the documents, how can they treat you as an exporter?
My lord, in that context, my lord, the appellate commissioner in his order from paragraph 7 to 9, your lordship can have a glance. They have clarified everything. Paragraph page number 85, my lord, it started. Page 85, paragraph 6. I find that in all the cases, it is the appellant who have entered into agreement with the foreign buyers. There is agreement in my favor. I have agreement with the foreign buyers to supply the materials. Then
in lordship, last three lines.
Then
in 3 lines, this is important. All these
contracts have specific mention on the face of shipping bill under which exports have been made. Though the shipping bills indicate Mr. Labor Marine Syndicate Private and Mr. Resource Private Limited as the exporter, but these persons have just filed the various shipping bills. They are not the real owner of the metal which is going to supply to the foreign buyer. I am the owner of the goods. I have supplied the materials, getting foreign remittance. I have the import-export code is there as because I have no plot at Paradip. I could not able to export that directly, so that I take the help of those two persons. Now, the department said that you are not eligible to get the refund. If you are not eligible, then they might have a claim. They have not a claim. They have no service tax number. Nothing. They are just working there as the go down agents in Paradip port. Everything else for export of goods has been done by the appellate. Has been categorical observation by the CIT appeal at paragraph 86. Paragraph 86, first paragraph, last line, my lord. In other words, except for the filing of the shipping bill, everything else for export of goods has been done by the appellant. Only technicality is that my name is not there in shipping bill and bill of that is only lacuna with me, my lord. Well, everything department has agreed and department has not agreed to the.
So let's look at your
export code.
Objection.
Yes.
Para 13.
With regard to apartment made in para 10, it is humbly submitted though the exporter has not been defined and either in the notification, number, students, or centers, goods, finance, but it is well defined in the Custom Act 220 and 20 exporter relation any goods at time between the entry of for export and the time when they are exported.
Includes.
Yes, Lord. Exporter relation goods anytime between the entry for export and the time when they are exported includes any owner or any person holding himself out of the exporter. But the fact remains, Lord, for the export, there are some document has to be executed. And both the document is never find, Lord.
That's right. But it includes. That's why it doesn't have to be only the person whose name appears.
Then, Lord, Entry has been defined in next paragraph. Entry. Entry in turnover 216 of the customer. Entry in relation to goods means or entry
Again
made in a bill.
Entry made in the bills means that description of the goods.
See, the agreement is with him. Only the bill of ladings and all are drawn in that man's name because it has to be dispatched. But the agreement is with him.
But for the
you'll have to analyze pursuant to which agreement is the export taking place.
But the fact remain for the exports and document is required, Lord.
No, but this is definition is broad enough to include this.
Lord, I understand, Lord, but thereafter, Lord, entry, Lord, is important, Lord. So, for the definition of entry.
Naturally, whatever is there in the bill of lading, that will be the entry.
If there is no name in the Lord exporter, he is not even exporter, Lord.
Sir, if the bill of lading is in the name of X,
yes,
only that will be in the entry.
But then, Lord, he is the main exporter. He is exporting, Lord. The person name of lading is the exporter, Lord. He is not the actual exporter. He is maybe not the executed agreement, Lord.
No. He is the exporter, sir.
That
the
is
other person is simply facilitating the actual loading of goods onto the ship to be sent.
Lord, the tribunal pays 91, your Lordship, kindly have a glance. Tribunal In the present case, the name of so and so were mentioned as shipping bill, and the time when goods were exported. Therefore, they are the exporter under the Custom Act.
That's the whole problem. There's no reference to this definition. If they refer to the definition, they would have known it can include even the actual owner, not merely the person who stays the bill of ladings.
No, my Lord, refund this cannot be automatic. My Lord, that must be a prescription of the Act, my Lord.
Yes.
And my Lord, in this Act, my Lord, if he is not expert, how can he refund back the amount which has been paid, my Lord?
Yes.
Actually, my Lord, the person, those have the naming in the bill of lading, Lord.
Yes.
They are the Lord, the exporter, according to my Lord, the department. Lord.
Yes.
Therefore, how can he claim, my Lord, that he is the exporter? Yes. Only because if he is the expert, then only he can claim.
So that's too simplistic. The agreement is with him. The agreement is not with those entities in whose name the bill of lading has been raised.
But if, Lord, there is an agreement, it should be mentioned in the bill of lading, Lord.
Because he does not own land. That's what the first appellate authority. Why don't you read the first appellate authority's order?
Lord,
you just read it. Such detailed discussion is there.
The paragraph
85,
7.
86.
At page 86, paragraph 7. Paragraph 8. The appellant did not have lease of land at Paradip Port. Therefore, the appellant could not
No, let him read. Let him read.
Paragraph 8.
Lord, it start. The appellant did not have leased land in Paradip. Therefore, the appellant could not export the goods. Though the Paradip Port, through the Paradip Port, in order to facilitate the appellant in export goods, so and so acted as a third-party exporter, Lord, which can be acceptable proposition of the law. In other words, export, except for the fact that name of so and so are appearing in the shipping bill, appellant in all assets exported the goods. Lord, this finding has been did not accept by the tribunal. But this finding, Lord, before the tribunal, we have challenged people because
just see para 7 also. You'll get a better picture.
It is also seen that the appellant had employed a clearinghouse agent to the export the goods. Further, stevedores had also been engaged by the appellant, and so also the behest of the appellant service provided for transportation in interport transportation, payment, uploading, and forage were engaged and paid for. Further, whatever expenses had been incurred by the show company were realized by them from the appellant. The survey, sampling, analysis, and quality assessment had also been done by the appellant. Under this contract, the appellant run the risks of the penalty if the goods are not exported or there are delays in export of the goods were below the specified. It is not out of place mention that LC had been opened in the bank by the appellant. The appellant had at all carries raised invoice in the sales of goods on the buyer and had in turn received the remittance of these exporter goods of their own means.
Essential document for export. Yeah. Important document.
Yes. LC is not as per appearance, not the order is named.
Yeah.
But so far as the export, not the he is
ostensible
not,
exporter is him.
Yes, Lord. He is, but the third party intervention is there, Lord. Therefore, the refund is not permissible in accordance with law. That is my submission.
All right. The present appeal by the SSC is directed against an order dated 20. Sorry. 20th July 2017, passed by the Customs, Excise and Service Tax Appellate Tribunal. Eastern Regional Bench, Kolkata, brackets stat. Allowing the department's excise appeal number 471 of 2012, and thereby setting aside an order in appeal dated 23rd April 2012, passed by the Commissioner Appeals in favor of the SSC. Paragraph. The SSC, you say, while admitting the present appeal by the order dated 10 February 2020, the following questions were framed for consideration by the court. Take from para 26 with grounds 1, 2, and 3. Paragraph. The background facts are that the appellant SSC filed 4 refund claims on 25th April 2011 in regard to service tax paid towards export of iron ore fines of various quantities in terms of a notification dated 7th July 2009. Full stop. The claims were rejected on the grounds that the shipping bills and bills of lading in all the cases were not in the name of the appellant SSC. And since it was not the exporter of iron ore fines, it was not entitled to refund in terms of the above notification. Paragraph. The exports were made through the Paradip port. Full stop. It was noted by the Commissioner Appeals in the appeal filed by the SSC against the rejection of its refund claims that the exports had made by the appellant through Messrs. Liberty Marine Syndicate Private Limited, bracket Liberty, and and Messrs. Resources International Private Limited, bracket RIPL, bracket. Full stop. The Commissioner Appeals, for examining the documents, found that it was the appellant which had entered into agreements with the foreign buyers and it is pursuant to those agreements that the exports took place. Full stop. Each of the contracts made a specific mention each of these contracts was specifically mentioned in the shipping bills under which the exports were made. Full stop. There were separate agreements between the appellant and Messrs. Liberty and Messrs. RIPL, under which the latter had a limited role, open quotation, in just filing the shipping bills, unquote. Full stop. Paragraph. The Commissioner Appeals further noted in para 7 and 8 of the order dated 23rd April 2012 as under, and reproduce whole of para 7 and 8 in page 86. Paragraph. The appeal of the SSC was accordingly allowed, and the SSC was held entitled to the refunds claim. Paragraph. The department then went in appeal before the SISTAT. Full stop. By the impugned order dated 20th July 2017, while setting aside the order of the Commissioner Bracket Appeals, the SISTAT held that under Section 2 bracket 19 of the Customs Act 1962 bracket Act and the term exporter under Section 2 bracket 20 of the Act it is Messrs. Liberty and Messrs. RIPL, whose names were mentioned in the shipping bills, who could be considered to be the exporters and not the SSC. Paragraph. The expressions single quotes entry, the expression export goods and the expression exporter as occurring in sections 2 bracket 16, 2 bracket 19 and 2 bracket 20 of the Act read as under. Paragraph. It would straightaway be seen that the definitions are inclusive in nature. Full stop. In other words, under section 2 bracket 20 of the Act, the term single quotes exporter would include any owner or any person holding himself out to be the exporter. So, in other words, the person holding out to be the exporter, bracket, in this case, Messrs. Liberty and Messrs. RIPL, bracket, need not be the only single quotes exporter, as recognized by the Act. Full stop. It could well include an entity like the present SSC, which has in fact entered into the agreement pursuant to which the export took place. Full stop. Added to this fact is the finding of the Commissioner Appeals that for the limited purposes of facilitating the export, separate agreements were entered into by the appellant with Messrs. Liberty and Messrs. RIPL, whose limited role was to file the shipping bills for the purposes of export in their names. Full stop. It has been factually further found by the Commissioner Appeals that the entire cost of effecting the export was borne by the appellant. Full stop. It ran the risk of penalties if the goods were not exported, or if there were delays in the export, or the goods were below the specifications. Full stop. Importantly, open quotation, the LC had been opened in the bank by the appellant. Unquote. Full stop. The invoices of sale of goods was raised by the appellant SSC on the buyers. And it is the SSC which had received remittances in its own name pursuant to the exports made. Paragraph. All these factors go to show that it was in fact the SSC which was the real exporter of the goods for the purposes of section 2 bracket 20 of the Act. Paragraph. Consequently, the court is unable to concur with the view of the tribunal that in the present case, the SSC was not entitled to the refunds since it was not the exporter. Full stop. Paragraph. Accordingly, the impugned order, the questions framed are answered in favor of the SSC and against the department. the impugned order of the tribunal is set aside and the order of the Commissioner Bracket Appeals is restored to file. Full stop. The refunds will now be made by the department of the amounts claimed by the SSC within a period of 8 weeks in accordance with the rules. The appeal is disposed of in the above terms.
Item number 20.
Madam, item number 20 is a tag matter. As per my lord's order 12th December 2022, it used to be tagged with the Income Tax Appeal 3 of 2019 and 4 of 2019, and orders are here.
Just call for that. We'll stay on boards.
No, my lord, it is 26th April, the dates are there, my lord.
Date your lordship has posted 20.
I see. Also list along with those appeals on 26th April. All right.
Item 21.
Got the numbers? Just pick.
I'm taking. Item 21.
The 21 lordship has already issued notice. 5/2/2020. May I request you also kindly keep it another email. One question.
Where Mr. Biswal is supposed to be appearing. Where is he? He's not here. Just let him know. We'll stay on board. Let him come.
Item 22.
May I please tell you? My lord, item 22. Before I submit the question of law, my lord, I pray to have a glance at the page number 36, my lord. The paragraph, first paragraph, last line. After adding 5% profit margin.
Page 36.
Well, page 36, Annex 7.
22.
No. Which STREV are you referring to?
STREV 4 of 2019.
Ah, that's the second matter.
STREV 4 of 2019. After adding 5% profit margin, gross turnover, taxable turnover is now determined this. So here profit margin is based on the profit margin is added 5% on the turnover to arrive the sales figure. And my lord, I just pray page number 29, my lord. The business is closed after this assessment order. Means the assessment order, impugned assessment order is 2001 and 2. And the business is already closed in the 16/10/2007 due to insufficient fund. My lord, these are relevant points. I submitted now. I will relate while after submitting the point. When the business is closed, the department accepted the profit at 5% by adding to purchase turnover. My lord, page number 27, my lord. The sales tax officer dropped the page number 28. My lord. Proceedings dropped under section 12(8). It is further revealed that the dealer maintains purchase account, files return, adding 10% profit margin on purchase turnover. It is also found from the examination of books of the dealer. Since the dealer maintains purchase accounts and pays tax on purchase turnover, credit sale after payment of tax on purchase does not attract any tax liability. No. This is what, my lord, the sales tax officer dropped under 12(8) of the Act. The sales tax squared on surprise basis visited and made an assessment. Page number 15, my lord. added 15% profit margin to the purchase value of disclose during the year. During that surprise visit, they just added, they took the purchase value and added 15% margin, whereas the sole proprietor was doing business by showing the purchase turnover, adding 10% profit margin. This was the pattern for last 18 years. And also when the business is closed for loss, it is also accepted at 5%. Whereas for that particular year, the sale tax squad, who has no idea about the assessee, demanded 15% profit margin. So it is the consistency is not maintained. Consistency is 10% plus on profit margin on the purchase turnover, whereas they demanded 15% for that particular year. And
what's the substantial question of law here?
My lord, substantial question of law is
nothing.
Whether on the fact circumstance of the case, the commissioner, while sitting in appeal, is justified in confirming against the order of the assessment commissioner on suo motu revision of an order passed by the sale tax officer related to a sole proprietor dealing in retail plywood sales who maintains purchase account which is not unlawful and files returns by adding profit margin and purchase price for last 18 years, having no adverse report, based on which the sale tax officer dropped the proceedings initiated under section 12(8).
How can you maintain this sales tax revision petition against so motor revision order?
Hello?
How is it maintainable?
Sales
tax revision, is it maintainable?
As it is the order, revision is revision order.
Tribunal order can only be amenable under
Revisable.
sales tax revision.
My lord, this is sales tax revision.
What is your petition? This petition is against the order of
Commissioner.
Against the order of sales tax.
Under which provision you have filed this? Against
the revision order.
Okay.
Revision order, how can you show us section 24 of the OST Act?
24 of 2, my lord.
Your application is under section 23(4)(c). That should have been an application.
My lord, if it is a revision order, it will come to High Court, my lord. That is the
High Court under what?
My lord.
Is it a revision or appeal?
My lord, assistant commissioner has revised and commissioner has set an appeal.
Appeal. Then you show us. How can you maintain this revision?
My lord, it was earlier.
We are in revisional jurisdiction.
My lord, I submit. It was.
So show us. How can we exercise the power?
My lord, I submit that. It was earlier a writ petition now and converted to ST revision as per my lord.
That's all right, because it can't be a writ petition anyway.
Just been appealed.
This court. He had filed only as a writ.
Section 23(4)(c).
It is that order.
Prefer an appeal. It says prefer an appeal.
Maybe, my lord, order may be passed accordingly.
No, so you have preferred the appeal to the commissioner. So against the suo motu revision, you went in appeal. The appeal is dismissed by the commissioner, right?
Well, assistant commissioner passed the revision.
Yes, yes, you have exhausted 23(4)(c).
You filed the appeal before the commissioner, you lost before the commissioner.
But my lord, if the order was passed by the commissioner to the High Court,
what?
It is said, any dealer, as the case may be, the state government agreed by.
No, if it is a suo motu revision.
Yes.
My lord, actually, it is
commissioner on his own motion.
My lord, I'm submitting.
Your suo motu revision by.
My lord, suo motu revision is done by
assistant commissioner.
Assistant commissioner.
So 23(c)(2).
My lord, where is the law is? Law is that only commissioner can revise.
No.
Assistant
23(c)(2), you please see, sir. If the order was passed by any authority subordinate to the commissioner. So that is what you invoked. You've exhausted that.
I understand. But whereas the commissioner, by confirming this order,
in appeal, he has confirmed it in appeal.
Yes, that becomes the commissioner's revision order.
No. It is the appellate order, sir. Under 23(c)(2), it is an appellate order of the commissioner. Because the suo motu revision was by the additional commissioner.
Therefore, initially it was filed as a writ.
Anyway, we'll treat it as a writ. Now, tell us, what is the infirmity for us to interfere in writ?
My lord, infirmity is that, or as a matter of consistency, they accepted for 18 years.
No, that is not a reason. Your business grows, things grow.
My lord, business has not grown. That is why the business, my lord, I submit now. Business is
can't be the same for 18 years, sir.
My lord, page number 36. The department again accepted 5% profit margin on purchase turnover.
We're not inclined to interfere.
Already the business is closed.
We'll treat it as writ petitions, and writ petitions are dismissed. Right. Interim order vacated. Okay. Yes.
Item 23.
May I please your lordship? Well, in the aftermath of the recession in the steel industry, the revenue devised this annual tax on annual capacity of production. And the annual capacity of production, my lords, was to be computed by the 30th of April. Now, in fact, as far as the petitioner is concerned, it was communicated to them in the third week of May. So after the cutoff date. So, my lord, the petitioner has paid up the day, whatever has been computed, as well as interest. But he was levied with penalty, which is what is being assailed before your lordships.
And your unit is closed now.
Unit is closed, my lords. Unit is closed since then. And my lords, I'll just rely on one judgment. Para 39, your lordship. A penalty, your lordship's got.
Can be levied by the authority.
Can only be levied by authority of statutory law, and section 37 of the Act, as has been extracted above, does not expressly authorize the government to levy penalty higher than rupees 5,000. This further shows that imposition of mandatory penalty equal to the amount of duty not being by statute would itself make Rule 96 ZO, ZP and ZQ without authority of law. We therefore uphold the contention of the assessors in all these cases and strike down all ZO, ZP and ZQ insofar as they impose a mandatory penalty equivalent to the amount of duty on the ground that these provisions are violative of Article 4.
This is under ZP3.
Yes.
The interest the mandatory penalty, my lord. That's what the Honorable Supreme Court has done. But if your lordship will come to the impugned order passed by the Honorable Sister at page 67, the Honorable Sister had reduced the penalty 25 to 25%.
No penalty at all. The rule itself is gone. They've struck down the rule itself.
My lord, so far as it is mandatory, that has been struck down.
No, the entire rule has been struck down, sir. Just read it carefully.
We therefore uphold the contention of the assessee in all these cases and strike down Rule 96 ZO, ZP, and ZQ in so far as they impose a mandatory penalty.
Yes.
So in this case, penalty has been reduced from 16 lakhs to 4 lakhs.
No. Once you can't have a mandatory penalty, that's the end of the matter, sir. You can't rewrite that provision. It only provides for mandatory penalty, that itself is gone. That's it. You see, the questions have already been framed.
So
No.
Questions have been framed, now. This is the last.
At page 8, my lord.
On 15th May 2019, while admitting the present appeal, the following questions were framed. Paragraph: admittedly, in the present case, penalty has been imposed under section Rule 96 ZP bracket 3 of the Central Excise Rules.
Yes. Finance Act.
Full stop. The said rule has now been struck down with the Supreme Court of India in its judgment in Sri Bhagwati Steel Rolling Mills versus Commissioner of Central Excise. I think we'll take the citation. There must be a citation. Where in para 39, it was held as under reproduced para 39. Paragraph with the Supreme Court having struck down Rule 96 ZP in toto, the question of sustaining the penalty imposed in the present case on the appellant does not arise. That view of the matter, the questions are answered in favor of the appellant and against assessee and against the department. The impugned orders of the SISTAT and the corresponding orders of the first appellate authority and assessing officer, insofar as the imposed penalty on the appellant, are hereby set aside. The appeal is allowed in the above terms.
The penalty deposited be refunded.
Or the amount of penalty deposited shall be refunded to the appellant in accordance with law within a period of 12 weeks.
Weekly list item number 24.
None appears for the petition. Dismissed.
Item number 25.
25 Merit. On behalf of Senior Counsel, Mr. Jaswant Das Merit, he is not well, Merit.
What's the matter about such a 2003 matter? Let's see what.
We have to file some substitution applications as per the last order.
Already filed. Already filed, that has not on record, Merit.
Copies may be served on us. No copy has been served.
It will remain on board, you serve a copy. Right.
Yes.
Item 26.
Maybe not. It's a short point in the case involved. I was not a party under Annexure 3, which was passed by the OA collector. And it was carried under Annexure 5, where the learned court have held that there is a delayable limitation.
You are a bona fide purchaser.
Madam?
Is a subsequent purchaser, Mr. Monty?
Subsequent purchaser.
No, Millard. This is 26. Satyabhama Misra.
Delay.
Millard, the counter is available. Your Lordship may go through the counter affidavit we have filed on behalf of the Tahsildar.
Counter is not given to me. However,
There's no counter here, sir.
my lord, the only point.
Delay in filing the appeal.
My lord,
Your appeal got dismissed on the ground of delay.
delay. I was
You are
not
not party to the original order.
Original order, I was not a party.
You are a bona fide purchaser.
No, no.
Ah.
No, I have got a house there on. Under OEA legible, possession is to be seen.
Okay.
But
So she only claims that I am in possession of the land. That is why the Tahsildar should have afforded opportunity of hearing.
The land,
the original recorded owner is hard.
the land is only one district in which I have only homestead. No, nothing else.
But
only my player, I must be hard at least on merit. Because I was not a party in the original proceeding.
30 years back, 20 years back, the order was passed.
But the house is there. It is not, that is my only claim. Only one district land, I have got a homestead over that. No homestead is there. Only I play that I must be hard on merit. And in OEA case, possession is a must. Unless possession is verified, it cannot be decided.
There's no interim order in your favor, sir.
No.
For 19 years, but you are continuing.
I am there. Only one dispute of land.
What happened? He's merrily carrying on.
This collector's order.
I was not a party collector. Past order that the Badway limitation. No, what is that? Well, I am given an opportunity to hard there. My house is there. Where I will go?
Lord, one thing can be done. He may be permitted to file revision against this appellate court's order, and delay can be condoned.
No.
As it is, the appeal delay was dismissed on the ground of delay only.
Delay.
We'll send it back to the collector. You see, the challenge in the present writ petition is to an order dated 3rd June 2003 passed by the collector Jajpur dismissing the appeal filed by the petitioner in OEA lease bracket R number 5 of 2002 against an order dated
against Annexure 3 and 5.
28 July 2003. Passed by the sub-collector, Jajpur. Thereby declining to condone the delay in filing of the appeal. The land in question is in plot 75 by 143 at measuring AC 0.02 decimal in Rameshwarpur, PS district, Jajpur. The delay of 12 years was sought to be explained by the present petitioners on the ground that they were not aware the decree dated 10 July 1986 . No, that the opposite parties were aware of the settlement of the land in favor of the petitioners by a decree dated 10 July 1986 in TS case number 132 of 1983. And yet approached the sub-collector years thereafter without including the present petitioners as parties. The present petitioners continue to remain in possession of the land in question. Stop. They ought to have been heard in the appeal filed by opposite party number 5 before the collector. Stop. On that short ground, the appeal order dated 3rd June 2003, the collector set aside. And the appeal being OEA lease R number 05/2002 is remanded to the file of the collector where it will be listed for directions. Collector Jajpur, where it will be listed for directions. On 1st March 2023, on which date the petitioners will appear along with a certified copy, downloaded copy of this order. The collector Jajpur will proceed to dispose of the said appeal afresh after hearing the parties in accordance with law within a period of 4 months thereafter. Till then, the status quo as of today shall be maintained. The writ petition is disposed of. Now that all you allow. All the substitution applications are allowed.
Item 27. Item number 27.
Note 3. This is in respect of cancellation of the Jawan lease deed, my lord.
There is no Jawan lease now.
There is no
that whole
concept
system
of
is
Jawan
gone.
lease.
Accept me person, Jawan lease, accept me person.
That's right. That whole policy is finished, sir. There's no more Jawan lease now.
My
petition has been rendered infructuous now, with the policy of Jawan lease itself having been scrapped by the government, state government.
This is of the year 2003, my lord.
That's what. The prayers made in the present petition cannot be granted. It will be open to the petitioner nevertheless to apply under the extant policy for whatever relief that the petitioner may be entitled to in accordance with law. The petition is disposed.
Item 28. Item number 28.
None appears dismissed now.
29.
To my misfortune, the file is misplaced somewhere in the court premises. But
All
my
right.
memory,
Let it
so
remain
far
on
my memory goes, my lord. It's a matter arising out of 783 probably, where the application is filed much belated. So may not have a very good case before your lordship.
I see.
So lordship may permit me to withdraw the matter with the liberty to approach the common law forum that will end the matter.
All right. Counsel the petition seeks leave to withdraw the present petition with liberty to seek other appropriate remedies as may be available to the petition in accordance with law. Disposed of is withdrawn with liberty is paid for.
Item number 30.
Item 30, your lordship.
My lord, on behalf of Mr. Misra, I seek on pass over, my lord. Pass over for today. Let the matter be kept on board.
Item 31.
Oblige, my lord.
I don't want to press it, man.
31.
Don't want to press it.
Dismiss is not pressed. All right.
Item 32.
This case is there for substitution of the legal heirs of the opposite party number 1. Madam. Opposite party 1 died during pendency of this case.
What's the challenge? Award.
Yes, madam. Out of the level.
What does the award do, sir? How much it is give him? What's the relief granted?
Reinstatement.
Full back wages. What does the back wages work out to? Reinstatement is now gone. He's died. What does the back wages work out to?
Punishment imposed was disproportionate, so it is first shocking. So on that ground, award was there. Reinstatement.
What is the amount involved, sir?
Amount might have not mentioned, but I have no inspection.
You see, this petition by the OSRTC challenges an award dated 4/10/2007, passed by the Labour Court, Jaipur, Koraput, in industrial dispute case number 10 of 2006. The reference to the Labour Court reads under, take from page 23. On merits, the tribunal found the termination of the services of the respondent workman to be unsustainable in law. And further, that the punishment imposed was, open quotation, strikingly disproportionate and quite shocking, unquote. Accordingly, the Labour Court directed reinstatement of the respondent along with full back wages. Paragraph. While directing, no. No formal notice has been issued in the present petition thus far. Except during the pendency of the present petition, the respondent has died. Also, an application has been filed for bringing his LRs on record. Paragraph. Considering that one part of the relief granted by the Labour Court has become infructuous, has become redundant with the death of the respondent, the court does not consider it appropriate to interfere with the remaining part regarding payment of back wages by dragging the family of the respondent into litigation after so many years. Full stop. On merits, again, the court does not find any reason to interfere with the impugn award of the Labour Court. The petition is accordingly dismissed. Right at the beginning, the substitution will have.
33.
May I praise the Lordship? I'm appealing to VC.
Yes.
I'm appearing for OP number 1 and 2 BTM.
In this case, the petitioner challenged the order that is 17/12/2008 under Annexure 3, where the opposite part number 2, in exercise of power under section 91(1) of the ODA Act, had directed the petitioner to remove the development which was taken without the prior to the permission of the BDA. But according to the fact of the case is that, Your Lordship, under Annexure 1, the petitioner has applied for construction of a steel plus 4 construction of a commercial cum residential complex, and accordingly permission was granted in favor of the petitioner. And thereafter, the petitioner immediately started construction of the said work. And under Annexure 3, the opposite party has directed to start the construction of the scheduled property, construction of the said building, on the ground that there is a deviation of the said construction. And accordingly, under Annexure 10, Your Lordship may
Is there an amnesty scheme now? There must be some amnesty scheme.
Yes, Your Lordship.
Appeal provision is there.
is an appeal provision is there.
Oh.
Under the Development Authority Act is a demolition order has already been passed. And that is, it is a mall. And in absence of any parking place and also deviation is a telltale, is admitted fact that deviation is there. And against that order, in fact, he hasn't filed an appeal. That's one exertion of an alternative remedy is there. Let him go and appeal.
Appeal to whom?
Appeal to the state government.
State government, Your Lordship. Section 2 of Section 91.
Section 91 2.
So you avail of that, sir.
Is aware
deposited. According to the scheme, we have deposited the amount and annexed 10, Your Lordship.
My deposit is not.
No action may be, no coercive action may be taken.
All right. You say against
paragraph
the
14.
demolition order passed against the appellant on 17/12/2008 by the Bhubaneswar Development Authority, (BDA). Admittedly, an appeal is available under Section 91(10).
91(2).
Subsection 2 of Section 91.
Section 91 (2) of the Odisha Development Authority Act 1982 (ODA Act) paragraph. Accordingly, the court permits the petitioner to avail of the above appellate remedy and directs that if such appeal is filed not later than 1st March 2023, accompanied by an application for continuation of delay.
Limitations.
That may be
the dependency of the present petition as the reason for the delay. Then it will be taken into account in accordance with law by the appellate authority. Till such time, if the appeal is filed within the time stipulated, then till such time the appeal is disposed of, the status quo as of today shall be maintained. Stop the court clarifies it has not expressed any view in the matter.
Provided limitation, because limitation.
We have already explained that, sir. Right.
It may be condoned.
Right.
Yes.
Item 34. 34.
My Lord, item 34, no instructions.
No instruction dismissed.
Item number 35.
None of this dismissed.
Item 36.
Lord, may I please? Lord, in this case, my Lord, the order of the Ombudsman on Annexure 6, page 25, has been challenged, my Lord. Your Lordship have glanced to page 25, simply 2, 3, 4 lines order, my Lord, heard both the parties. It is concluded that the respondent is directed to extend the TOD benefit, although the recorded based data during TOD hours may not be available with the respondent to the petitioner's industry for the period from 2007 to 2009.
What is the current status, sir? You took time last time.
My Lord.
You had taken time last time to find out about current status.
My Lord, industry under disconnection since last.
We asked him, sir. He took time last time.
Power supply has been disconnected to the unit.
Then why should this
because
order come in effect too?
There is a area outstanding by Lordship kind of TOD is mandatory, they have to give, my Lord. From 2007, my Lord.
The unit is no longer there. What's the point? That's what
because area outstanding there, they are claiming area outstanding, my Lord. That has been taken into consideration, my Lord.
Are you there? You're not there. What is the instruction?
Power supply has been disconnected.
Your unit is still operating.
By own arrangement, he has run.
Own arrangement was with generator.
Yes, sir.
5 crores is the rear outstanding, my Lord. And
that is your Lordship with 3 cases, 3 units are there. One by one, they have to disconnect the power supply. And the sole claim is that TOD benefit, whether the industry is entitled to get the TOD or not. And that has been taken into consideration. The very same authority, they have extended to the South Co, my Lord.
Entitled to the TOD benefit, my Lord. What happened, my Lord?
Because they have extended from 2010. But they have not extended 2007, my Lord.
My Lord, when the new meter was installed, TOD benefit is based on meter data, my Lord. Based on meter facility, having recording that facility to record the hourly consumption. If the consumer avails power during off-peak hours, that is from midnight 12 to next day 6 a.m., then only 10 paise reduction is available as per the ORC tariff order. That meter, a new meter was installed in the context of operator technology, license installed a meter in 2010, and that benefit is being granted to him by that time. Subsequently, he filed a case before the grievance redressal forum in 2000, praying in 2010 a case was filed, praying that For the back period from the date of power supply 2007 to 2009, he should be given that benefit. GRF said.
Just come to the impugned order, sir. The ombudsman's order.
My lord.
Come to the impugned order.
Impugned order, my lord, your lordship, Annex of 6.
Just read it. It's a very short order.
Yes, my short order. Prior to that, my lordship, kindly turn to the order passed by the GRF, my lord.
You come to the ombudsman's order, sir.
Yes, my lord. Both the parties are present today, my lord. Endeavor is made to promote an amicable settlement between the parties. It could not be materialized. Therefore, it is choose to decide the matter after hearing the parties today. Had both the parties, and it is concluded that the respondent is directed to extend.
What is this concluded? No reasons, nothing. This is so convenient to pass orders like this, sir.
No, that is true, my lord. Everything has been reflected in the GRF order, my lord.
Kind of orders. We are supposed to give
everything has been reflected in the GRF order, my lord. After your lordship, industry meter installed 2007. Intentionally, they have not installed the starting meter. Petition approach the time and again. That has been turned down. They have installed their new meter in 2010 January, my lord. Thereafter, TOD benefit has been given. What prevented them to install a new meter? Your lordship, kindly 54.
Don't even have the record, sir. Although recorded base data during TOD hours is not available.
Yes.
Despite that record not being available, you are supposed to be giving granted benefit. Because it is there, lordship 54. I am reading out the rule 54. Yes. Initial power supply shall not be given without a correct meter. It is the fault of the authority. They have not intentionally, they have not installed the starting meter.
56.
I time and again approach the authority for installation of starting meter, having TOD facilities.
56.2 says that the installation of meter.
And they have not 56.2 after 54. Not before that.
Of installing a meter at his up to the license standard, my lord. My lord, if he could have availed power supply in 2007 to 2009, he could have made objections or he could have taken steps to install a meter having that facility. My lord, that was not done because he was not availing power supply in the off-peak hours. That is why the GRF has said that if the dump data is available, then it can be given. Since it is because of the scrolling of memory only exists only for 1 month, and how can it be said that what extent of power
we have availed the power for 24 hours, my lord? No. That has been taken into consideration, and thereafter we have approached the authority time and again. First 6 to 2008 finally dependency. Then 4 for 2008, 6 to 2009, 10/7 2009. And that has been turned down. And on so motor they have been installed in 2010 January.
No, license has power to install the operator.
But because you have to supply the correct meter. 54 says. If you will say refuse that there is no such meter is available, it is the duty of the consumer to provide.
Please, my lord, I request my lord to go read 56.2, my lord.
54 first.
56.2 says.
Initial power supply shall not be given without a correct meter.
My lord, in a case, the consumer, in accordance with section 55 of the regulations framed under section 73 Act, may himself procure the meter either from the vendor certified by the licensee, confirming the licensee's technical specifications, or request the licensee to supply the meter. That endeavor he has not made.
Where you have stated that a correct meter is not available, not a single letter you have intimated to the consumer.
And ombudsman has blindly said that you extend the benefit.
Because the same benefit has been extended to the South Coast.
Yes, the meter is available. South Coast is
taking it to 33%.
If there is no proof, there is no basis, how can it be granted?
We challenge the present petition by the North. So what is the present name nomenclature, sir? By the Northeastern Electricity Supply Company of Orissa Limited, NESCO. Now it's known as North Tata.
Now it has taken by Tata. Now it hasn't taken.
TPNODL. TPNODL. Now taken over by Tata Power North Orissa Distribution Company Limited. Is to an order dated 24th September 2010, passed by the Ombudsman. In the consumer representation case number OMB (2) (N) 37 of 2010, filed by the NESCO. No, filed by the consumer, that is the respondent.
Yes.
Pradhan Industries Limited, bracket PIL. Bracket. The above case before the ombudsman was filed by PIL, agreed by an order dated 27 July 2010, passed by the Grievous Redressal Forum, bracket GRF, bracket, of NESCO in Jashpur. Holding that in the absence of any record-based data, the benefit of TOD cannot be extended to the respondent consumer. Full stop. The order passed by the GRF was a direction being issued to the present petitioner, NESCO, to extend the TOD benefit to the PIL during December 2007 to December 2009, as per the preserved dump report, if available. Full stop. It was reiterated that, open quotation, TOD benefit can only be extended on record-based data, unquote. As far as the ombudsman is concerned, in a cryptic 2-paragraph order, the plea of the consumer is allowed. Full stop. The said order reads as under. Reproduce the whole order at page 25, Annexure 6. Paragraph. On the face of it, the above order is a non-reasoned one. Full stop. It only sets out a conclusion and proceeds to extend the TOD benefit to the respondent, despite noting that the record-based data is not available with NESCO. Full stop. Without there being a recorded data, the question of extending the TOD benefit to the respondent simply did not arise. Full stop. The ombudsman could not have passed such an order, and that too without any discussion of the reasons that weighed with the ombudsman in issuing the above direction. Paragraph. The impugn order of the ombudsman is accordingly set aside as being unsustainable in law. Full stop. The order of the GRF is restored to file. The writ petition is allowed to the above terms, no costs.
Lordship, Annexure A by 200, to my counter, your Lordship, I'll take it into consideration.
All right. You can stop.
Your Lordship, okay.